order call case numbers 2751/2021 and 2752/2021, MP Zulu and another, the subsequent B matter and others.
The appearances are as per yesterday.
This is a ruling on the application by the applicant Queen to amend. After this court has ruled that in the papers before it is not asked to determine and make a finding on the validity of the subsequent marriages of the late king with other wives or queens, the applicant queen brought an application for an amendment of the applicant queen's notice of motion to include a prayer that all subsequent marriages between the late Isilo and the first to the fifth respondents are declared invalid. Unquote. Madonzela for the second, sixth, and 12th respondents objected to such an amendment on the grounds that the respondents have at all times made to believe that, or let me repeat this, the respondents have at all times been made to believe that the validity of the subsequent marriages has not been an issue. Consequently, this has not been the case they have expected to meet. If the notice of motion is accepted, or if the amendment of the notice of motion is accepted, it will not be supported by the papers before court, or it will be at variance with the applicant queen's founding affidavit and replying affidavit in particular. Allowing amendment will amount to introducing a new cause of action altogether. The amendment sought will not only prejudice the first to the fifth respondent as the late king's queens, but it will have a far-reaching consequences even to their children, since their legitimacy will also be at stake. And even those who were born out of wedlock will be affected. He asked for the dismissal of the application in court. He went on to argue that it is not in the interest of justice and of the public that the case of this nature be delayed. The application in its submission should have been properly brought under Rule 28 of the Uniform Rules of Court. Mr. Topping for the third, fourth, and seventh respondents also opposed the applicant. The applicant's application to amend the notice of motion on the grounds that it will change the whole scene of this case, and the applicant queen should not be allowed to change horses midstream. The prejudice to be caused by amendment of the notice of motion cannot be cured by an order of cost, adjournment, or postponement, as the entire affidavits have to be refiled. Mr. Redman for the applicant Queen said that the invalidity of the subsequent marriages will only impact on the division of the joint estate. Rule 28, sub-rule 1 of the Uniform Rules of Court sets out the procedure which should be followed in the event of a party desiring to amend any pleading or document other than the sworn statement filed in connection with any proceedings, shall notify all other parties of his intention to amend and shall furnish particulars of the amendment. However, the court may, in exceptional circumstances, allow amendment of the pleadings at a later stage. Rule 28, sub-rule 10 of the Uniform Rules of Court provides that the court may, at any stage before judgment, grant leave to amend any pleading or document on such other terms as to cause or other matters as it deems fit. The applicant Queen has applied for amendment at a very late stage of the proceedings, and no reasons have been advanced as to why it was not timelessly raised, so to enable proper investigation and response thereto by the first to the fifth respondent. So this also finds supporting that in the decision of Tengwa versus Metro Rail 2002 Volume 1 SA 739 C in brackets of the Cape Division. The application was launched in April 2021, and Prince Mangusu Tukchelezi, in an answering affidavit filed in July 2021, clearly brought to the notice of the applicant Queen that her averments relating to the validity of the subsequent marriages were not clear, and stated that he will assume that their validity was not in issue and that they are deemed to be valid. However, the applicant Queen, in her replying affidavit of the 21st of July, did not address that issue. As a result, the clarity sought was therefore not provided. And nor did she indicate that she would amend the pleadings. No indication has been given to the respondents that an application to amend will be brought up until after the ruling yesterday. Nor has any reasonable satisfactory account has been given for such a delay and why this application has not been timelessly made. If the application for amendment is not timelessly made, as in the present case, some reasonable satisfactory account must be given for a delay that was said in the case of Kaufman versus Van Rijn in 1926 OPD 8194, and also Kraus versus SAR&H 1948 3 SA 1145, that also the OPD. Even if the party applying for for amendment tenders to pay costs and to consent to a postponement and other conditions and terms which will avoid all direct prejudice to the other party as regards his prospects of succeeding in the action. That will not entitle him to claim amendment as authorized, but he will have to show reasonable grounds which are in the present case absent, and no reason whatsoever has been advanced for making this application at this juncture at all. So the procedure set out in the rules was not followed or honored to the prejudice, not only to the prejudice of the first to the fifth respondent, but to all other people who will be affected by the granting of the relief sought. As a result, the application to amend is accordingly refused.
Njengamanje ke inkantolo isisiphile isinqumo sezolo esimayelana nesicelo sesafakwa sokuthi ke sizokhumbula ke ummeli ke omele ke uNkulunkulu lokuyena ngumfakisicelo kwezifakisicelo sokuthi ke na kube nezinguquko noma nezinto abazisana ke lapha zokusekela ke amaphepha emveni kokuba kuye kwavela phambi kwenkantolo ukuthi ngokwamaphepha labathi bawaletha enkantolo isicelo isicelo sakhe lesokuthi ke na beveza ukuthi ke kungani kufanele amanye amakhosikazi eza ngemva kwakhe umshado yawo ingathathwa njengomshado ke esemthethweni. Kodwa ke uthe meseveza uvezeke kamuva sivile ke beyiphendela ke abamele laba bangasohlangothini ukuphikisana nalesi sicelo. Kodwa ke bavezile izathu ukuthi ngempela ke lokhu kungaba nempindezi ke enkulu futhi kungaba nanomthelela nakwabanye ke abathintekayo ngalolu daba ngezathu ezahlukene ngoba phela manje uma ngabe kunikezelwa ke isicelo ke esibhalwe phansi ke la esibhalwe nodaba sozodingidwa enkantolo, lokho ke kunemlando noma ke kunezinyathelo ezilandelwayo. Akuveli nje bese ke kufakwa isicelo noma bese vele kunikezelwa amaphepha lenkantolo phele kanjalo, kodwa kufanele banikezelele nababe nethuba lokuyobheka futhi babe nethuba lokuthi bayiphendele ngalezo zinto esezeyivezile. Manje la kulolu daba akuzange kwenziwe ngendlela efanelekile ngoba uma ubheka lolu daba ke noma mayelana nokufakwa kwalesicelo esizela enkantolo kulokhu kwafakwa kusona ngo-April kunyaka ophelile ka-2021 kwaze kwaba ukuthi ke kunikezelwa ithuba inhlangothi ukuthi nazo zidingide zibheke kwamaphepha ukuze nazo ziphendule ukuthi ngokwalesi sicelo sesifakwa ke indlovukazi bona ke bathini ke lokho. Nanokuthi ke futhi uma ubheka lapha iphuzu layo ke indlovukazi le uNkulunkulu ngisho ke encazeleni umntwana ke la ubaba uma ngosuthu lesikhathi ke esephendula lapho ke ngoJulayi encazeleni yakhe esitatimendeni sakhe wonke akusobala ukuthi kahle la kulesi sicelo esifakwa uNkulunkulu akucacile kahle udaba lakhe olumayelana nokuthi kungabe njengoba ke efaka ukuthi ke ufuna kube imishado yoza kwabo uzobisa ke kanjani ke na ukuthi ngabe ngoba mhlawumbe ufuna kube khona izinguquko ngokugcwele kuyonke ke into ekhona noma yena welelwa ingxenye efanayo ukuthi izayena njengoNkulunkulu nakho kuphela. Kodwa kwangacacile kwakuphela kusobala ukuthi kusho ukuthi akaphikisani nale mishado yabanye oNkulunkulu abanelamanye na lokho kusho ukuthi phela manje uma usubheka futhi nalesikhathi sephendula ngoJulayi bona ke nasohlangothini labo lethimba labameli bakhe abazange futhi ke bachaze noma baphendule nokuthi ke na kungabe ke bayaphikisa. Manje ke lolu daba labo umqala ukuvezwa izolo bese kulate kakhulu ngoba vele lolu daba selisezithebeni zenkantolo ukuthi inkantolo ilalelele manje isicelo sakhe ke uNkulunkulu mayelana nokuthi ke inkantolo yenze izinguquko ngoba uma usubheka side isikhathi bekade vele ngasonke lesikhathi ngisho kusekhona ke isilo singakhothani bekungekho bekuveza noma obevezwe ukuthi kunenkinga noma ukuthi imishado yalabo abanye oNkulunkulu mhlawumbe njengomshado ke enenkinga noma engamukelekile. Manje ke vele umthetho unayo ukusekela noma le mishado ukuthi ke ngezathu ukuthi phela njengoba bemshado lo wesilungu nalaba bangeke Manje-ke azikho izathu-ke la ezizwakalayo neziphathekayo zokusekela isicelo sakhe sokuphungana kufanele inkantolo imgunyaze ukuthi manje alungise amaphepha akhe. Kona-ke kwamanje sekudaba lokulungisa amaphepha akhe emzukulu, kodwa inkantolo iyabona ukuthi cha, ukubheka isikhathi sekuphazamisekile ukuthi isikhathi sekulate, azikho izathu ey'bambeka zokuphungana inkantolo kufanele ibheke imukele udaba kanti ukuphungana kufanele kuqale kabusha. Lokhu kuzochaphazela abanye abantu abaningi akhona nje inhlangothi ezithile ezahlukene naney'ngane zakhona abantwana abanabasezukulu nanabanye abantwana-ke laba abatholakele ngaphandle. Ngaleyo ndlela inkantolo okwamanje sasithithile isicelo siphambi kwabameli bandukulu sokuthi-ke nakhona izinqubo ngokumaphepha.
Yes, Mr. Redman.
Thank you. Well, the right of the ruling yesterday today obviously limits some of the issues.
Can I hear you?
Hello? I apologize.
Yeah.
Hello? In the light of the ruling your Lordship made yesterday and today, it would obviously limit some of the issues which I intend to argue. The outstanding issues, my Lord, would be whether the applicants are entitled, or the applicant in the Queen's application is entitled to the relief sought in clause 2A, B and C of her notice of motion. My Lord, your Lordship will recall that this application was launched, the Queen's application was launched pursuant to the publication of the will of the late Cedar. Your Lordship will find the will at Annexa SWZ 4 at page 71. It's volume 1 of the bundle of documents.
Is that volume?
Volume 1, page 71. In the relevant provisions commence at paragraph 3, which reads as follows. There is a stamp over the writing, but one can discern what he said on the page. The notion of marital in-community of property is foreign to Zulu people, regardless of their soul and financial standing. Perhaps I can refer to them in his argument. We'll be back to you because otherwise it's difficult to read.
What do you say about paragraph 3?
Lord, I cannot read what is, regardless of their financial, I think that's standing in the Zulu has ever got married or not. I've been legally advised. If your Lordship was being with me once I might know the trainers give me a clear copy. Thank you. I might start at paragraph 3 again. The notion of marital in-community of property is foreign to the Zulu people, regardless of their social and financial standing no Zulu king has ever got married to one wife in community of property. This is because of the nature of the laws and culture. Now that's the commencement is that the king in his world opines that there in fact can be no marriage in community of property under the Zulu customary law. He says, I've been legally advised that in recognition of the fact that the notion in community of property is foreign to African people, even governments prior to democratic dispensation legislated in Black Administration Act 1927 that unless there was a prior agreement to the contrary between the intending couples at least 30 days prior to the wedding day, a civil marriage among black people was automatically out of community of property. It is common practice among the Zulu people of today and many other African peoples to undergo a marriage ceremony under at least three systems: traditional, religious and administrative. The latter denotes the registration of a marriage in an appropriate government office. A religious one at one time was intertwined with the latter, as priests were also officially appointed marriage officers. Traditional marriage denotes marriage according to custom. I am no exception to this. In my lifetime, I got married to 6 queens as my wives. In each instance, I had consummated my marriage according to all 3 marriage systems, or some of them. Now, my Lord, at the outset, that is obviously erroneous in the sense that one cannot consummate 3 marriages under the civil law. One cannot consummate more than 1 marriage under civil common law, my Lord, under the Marriages Act. Now, my Lord, what is of significance in the will is the suggestion that the king had married all of his wives under all three systems. My Lord, the applicant brought the application where she sought a declarator in order to assert her rights as a person who was married under civil law in community of property. Now, my Lord, in prayer 2B of the notice of motion, the applicant sets out the declarator she seeks in this regard. She says she seeks an order declaring the marriage between herself and the late King Goodwill Zwelithini Zulu was concluded on 27 December 1969 and was a marriage in community of property. That's on page 4. She further, my Lord, seeks at prayer B an order that during its entire existence, the marriage in paragraph 2A above was subject to the Marriage Act, and all subsequent customary unions celebrated or entered into by the late His Majesty King Goodwill Zwelithini were precluded by the existing civil marriage to Her Majesty Queen Sibongile Zulu. So she wants a declarator, my Lord, in addition to the declarator that she was married in community of property. She seeks a declarator that all subsequent marriages concluded by the late King were precluded throughout the period of her marriage. That, my Lord, you would accept that the period of her marriage would have been up until the death of the late King. So she seeks those 2 orders, my Lord. She sets out, my Lord,
if you say 2 orders, 2A and B.
She seeks A and B, my Lord.
6A.
B, and she also seeks C, my Lord, but I'm dealing with the first 2, A and B.
So, Mr. I'm not sorry whether, you said you need 15 minutes without interruption.
My Lord?
You said you need 15 minutes to address without interruption.
15 minutes, my Lord?
Not what you said yesterday.
No, my Lord.
Okay, can I put the question to you?
Oh, yes, brother. Yes, I did say 15 minutes uninterrupted, my lord. But yes, I'm willing to accept questions, my lord. No issue.
Well, it is a known and accepted fact that the proprietary consequences of the marriage in common property is that the parties to it equal shares.
My lord, is your lordship asking me whether it's common cause between the parties that the marriage was...
No, that is law.
Yes, my lord, it is law.
Of the marriage.
Yes.
One party does it to 50% of the joint estate.
Yes, it's married in community of property.
Yes.
My lord, and in this particular instance, the parties had elected to get married in community of property. That your lordship will note from the marriage certificate and the declarations that were made by the parties at the time of their marriage. They agreed, my lord, to get married in community of property. So that is what the Queen says, and that was her case.
And that is the law.
That is the law now, my lord.
That is law in terms of the Marriage Act. That is the law in terms of the common law. That is also the law now in terms of the recent decision
Yes, my lord.
of the Common Court.
Yes, my lord. Yes.
So now the law is here. Why is the need for declaration?
Well, the first declaration your lordship will note is the declaration that she was married in community of property under the Marriages Act.
Is there anybody disputing that?
There was initial dispute of that, my lord. There was most certainly a dispute of that. In fact, to the extent that the respondents brought a counter-application or conditional counter-application for an order that that marriage be declared, that the civil marriage was null and void. My lord, that is part of the answering affidavits which were delivered on behalf of the respondents. It's only in the recent supplementary affidavit, the one which was delivered this week, my lord, that last week I think it was, heads of argument, the supplementary heads of argument, where they for the first time concede that the civil marriage was valid.
But it's now conceded.
It's now conceded, my lord, for the first time in the heads of argument. It's hotly disputed, my lord, in the answering affidavits, and it's disputed in the will itself, my lord. That is the purpose for launching of the application. So our submission, my lord, and if I might take you to the concessions, my lord, the concession your lordship will find I think it's paragraph 76 of the supplementary heads of argument.
Whose supplementary heads of argument?
The supplementary heads of argument delivered on behalf of
the respondents.
Of the respondents. In fact, it starts at paragraph 68 at page 29. And then they go on to page 73, paragraph 73.2, where they say, they refer to Nkumbula versus Linda, concerned the first phase. It did not concern the validity of subsequent civil marriage, but the proprietary consequences. Indeed, the court recognized that a subsequent civil marriage could be concluded and confirmed the consequences for earlier customary marriage was, and then sets out what the provisions of the earlier customary, what the position was in relation to the earlier customary marriage. But they concede, my lord, and I'm certain they will in argument, that the civil marriage was in fact a valid marriage under the Marriages Act of 1961 and was a marriage in community of property. But up until these heads of argument were delivered, that was hotly disputed and was an issue which needed ventilation before this court.
But with such concession, is it not necessary now to make a declaration?
Well, my lord,
that's law.
But my lord, it's not only law, my lord, it's also fact. Because bearing in mind the question as to whether there was in fact a marriage. In the King's will, he had suggested that in fact he was married to the the Queen out of community of property.
That is not in dispute.
My Lord?
That is not in dispute that they
At this stage, but it was in dispute
property.
and that's why we seek the declarative, my Lord. The
The
declarative
King
will
also
put,
concedes that he
They
admits
conceded-
in his will that he entered into a marriage in common property. He concedes that.
my Lord,
And
perhaps,
also there is a copy of the certificate and the register to that effect.
attached to the founding affidavit, yes, my Lord.
Yeah.
That's the proof that we had to bring in order to establish that it was in community of property, and to show what the agreement was, which had been concluded between the late king and the applicant. It was necessary for the applicant to establish that in fact there was a marriage, and that the parties had agreed that the marriage would be in community of property. That, as I say, was disputed up until this week, that marriage was a valid marriage under the... And indeed there was, as I indicated, a counter-application in that regard. So, was it necessary to seek a declarator? Our submission is yes, my Lord. And my Lord, if it was unnecessary, or no, let me retract that. Let me say, my Lord, if the respondents suggest, well, this was always their position, why did they not simply concede and accept in their answering affidavit that that was the position, and that there was in fact a valid marriage between the applicant and the respondent? My Lord, there's no plausible reason we submit why this court should not grant a declarator in these circumstances. It doesn't appear to be disputed that that is the legal position. It doesn't appear to be disputed that that is the factual position. So, my Lord, what prevents the court from simply stating to resolve any future dispute which may arise as to this marriage? The court can endorse and simply say there was this marriage by civil law and it's in community of property. And that's the declarator we seek. And it's a live issue, my Lord. It's been a live issue since the commencement of these proceedings. And the court is empowered, and we submit should make an order declaring the marriage. And my Lord, it's not hotly disputed any longer. So the court can make that order. And my Lord, to decline to make that order may result in the parties in the future entering into another dispute on the self-same issue as to whether there was in fact a marriage or not. We've proved there was a marriage, we've proved it was in community of property, and we've proved it was in terms of the Marriages Act, and it's valid and enforceable. We submit we've made out a case for the marriage. My Lord, the second issue is the Queen seeks an order that during its entire existence the marriage was subject to the Marriages Act, and all subsequent customary unions celebrated or entered into by the late King were precluded by the existing civil marriage to Her Majesty Queen Sibongile Zwelithini. So she seeks an order that all subsequent marriages were precluded. Now, my Lord, at paragraph 65 of her founding affidavit, the Queen states the following. She says, page 37, she says, by virtue of the nature of our marriage, Isilo was not legally capable or permitted in law to enter into any other marriage while our civil marriage existed. We have never been divorced and remained married to each other in community of property until the death of the late Isilo. Now, in those circumstances, she contends that the late Isilo was precluded by the existing marriage to enter into any subsequent marriage. Now, our submission, my Lord, is that it's quite clear on the law what the position would be. Once one elects to get married under a civil, in terms of the Marriages Act, in civil law, one elects the matrimonial property regime, and one elects that the common law will be applicable to that marriage. If one got married under customary law, one wouldn't be entitled under the new Act, under the Recognition of Customary Marriages Act, to get married under civil law to any other spouse, and vice versa. So if one got married by civil law, one elects that the common law will be applicable to the future of that relationship. And the common law precludes any subsequent marriage, whether by customary law or by civil law. One cannot have a dual civil and customary marriage. And my Lord, we've referred in our heads. I've dealt with this at some length in the heads of argument, what the position was under the common law. Now, once one got married under a common law marriage, under civil marriage, the position, my Lord, is that one cannot enter into a further marriage. And my Lord, we've referred to Bennett's Source Book of African Customary Law, and I believe extracts of the relevant unreported judgments and the articles were handed up to your Lordship. Lord?
They were handed up in the heads of...
No, not handed up, but were filed, my Lord.
I haven't seen them.
There was a bundle of authorities as well as references to textbook.
In the bundle you handed up yesterday, or...
No, it wasn't anything I handed up yesterday. It was in fact filed, my Lord, I understand.
Updated comprehensive heads of argument. That's the one I'm referring to.
I believe they were filed together with the supplementary text.
Today.
We have an additional copy which I might hand it up. Contains the unreported judgment of the authorities. And I don't intend to take your Lordship through the entire argument, more particularly in the light of your Lordship's ruling yesterday afternoon. But I do intend to just refer your Lordship to certain extracts from the authorities below. Your Lordship will see that in that bundle of documents, they numbered each article and each unreported judgment. And if your Lordship looks at the Source Book of African Customary Law, which your Lordship will find at article number 9. Lord, and in that article at page 458 of the textbook law, it sets out what the customary law position was. Paragraph 4. It says, a customary...
That's 458.
My Lord, 458. is a customary marriage by a partner to a subsisting civil Christian marriage with a person other than the civil law spouse. It says, if the spouse of a civil Christian marriage purports to enter into a customary union with a person other than the spouse of common law, the second union is null and void. And your Lordship will find the footnote. There are a number of judgments, my Lord. All of them, page 458. I'm not sure what page it is. It's item 9. And my Lord, all those cases, we have inserted the case of Kumalo versus Kumalo in the heads of argument, so in the bundle of authorities. And your Lordship will find that authority, and it's on exactly the same point, and it determines, the Lord, under the common law, any subsequent marriage was null and void. And my Lord, the position has not changed. If one got married, if one elected to get married under the civil law, one could not in 1969, nor can one now enter into any other marriage or union outside of that civil law marriage. And that includes, my Lord, and I emphasize this, it includes one cannot enter into a civil marriage. One cannot now say, well, I want to enter into a civil marriage with another person. The civil marriage is a monogamous relationship. Under the common law, it is recognized as such. And under civil marriage, by electing to get married under civil law, one is electing to get married in accordance with the common law of South Africa.
Well, in fact, the position is same, even if it's another civil marriage, you can't, if you enter into the first marriage, you can't enter into a subsequent one. The subsequent one is
exactly the law. And my Lord, the common law position, my Lord, has been codified in the Recognition of Customary Marriages Act. That specifically reiterates exactly the same position. And my Lord, in our heads of argument, if I might take your Lordship to page 19 of our heads of argument, at paragraph 57, we say, prior to the promulgation of the Recognition Act, the Law Commission's Special Project Committee on Customary Law investigated and recommended the retention of the existing common law rule, namely that civil Christian form of marriage prevails over that of pre-existing customary marriage. And then these recommendations were incorporated into the Recognition Act. The Recognition Act then provides as follows. Section 2(1), a marriage which is a valid marriage of customary law and existing at the commencement of this Act is for all purposes recognized as a marriage. 2.3, if a person is a spouse in more than one customary marriage, all valid customary marriages entered into before the commencement of the Act are for all purposes recognized as marriages. 3.2, save as provided in section 10.1, no spouse in a customary marriage shall be competent to enter into a marriage under the Marriage Act during the subsistence of such customary marriage. The proviso in 10.1 reads as follows. A man and a woman between whom a customary marriage subsists are competent to contract a marriage with each other under the Marriage Act if either of them is a spouse in a subsisting customary marriage if neither of them is a spouse in a subsisting customary marriage with another person. So if one is parties who are in a customary marriage are entitled to get married in by civil law, provided neither of them is married to another person. And that, once again, reiterates the monogamy of the civil marriage. My Lord?
So, what would be the effect of recognition of customary law?
I'm coming to that.
Does it, I believe, the status of the customary marriage?
Not void marriages, not only marriages which existed, and that would be marriages which were valid and valid marriages at the commencement of the Act. Now, I know your Lordship indicated in your Lordship's finding that your Lordship is not required to determine the validity of the marriages. Our argument has always been, as your Lordship heard yesterday, that this is an issue.
This is a legal position. What is the legal position with regard to the RCMA? This is legal
position under the RCMA. My Lord, the position under the RCMA, there's two issues relating to the RCMA. First issue is that comes as to the question of whether these marriages, the subsequent customary marriages, were somehow recognized by virtue of section 2.1 or 2.3 of the Act. Alternatively, my Lord, the other issue which arises is the question as to whether a marriage entered into after the commencement of the recognition of the Customary Marriages Act is a valid marriage if it was entered into as a second marriage in the place of a civil marriage. So, my Lord, if I can deal with the second question first, is because this is I've shown your Lordship that under the common law, the case law is very clear. A civil law marriage precluded a party from entering into any other marriage after that date, or any other union after that date. And the cases are all set out, my Lord. Khumalo versus Khumalo we provided your Lordship with, which specifically says that marriage is void. So the customary marriage entered into in the face of an existing civil marriage is a void marriage. The next question, my Lord, is did the Recognition Act, so any marriage entered into after the Recognition Act, did that somehow allow for that type of situation? Now, my Lord, paragraph 10(2) reads as follows. When a marriage is my Lord, of the Recognition Act, my Lord, I'm still on page 20 of my heads of argument.
Okay. Page 8.
It's paragraph, section 10 in brackets 2 of the Recognition Act, and it's a paragraph, page 20 of the heads of argument. Yes. It says, when a marriage is concluded as contemplated in subsection 1, the marriage is in community of property and of profit and loss unless such consequences are specifically excluded in an antenuptial contract which regulates the matrimonial property system of their marriage. So that's if parties who are parties to a customary marriage enter into a civil marriage, then it will be in community of property unless they enter into an antenuptial contract. Now 10.4 is the relevant clause. It reads, despite section 1, subsection 1, no spouse of a marriage entered into under the Marriage Act is during the subsistence of such marriage competent to enter into any other marriage. The commencement of the Act, my Lord, was 15 November 2000. So the position in law is clear, my Lord. Prior to the Recognition Act, the common law position prevailed. And the parties were precluded from entering into another marriage if a civil marriage was in existence. And the common law is set out in all those cases which I've referred to. Subsequent to the commencement of the Recognition Act, that self-same common law position was reinforced. And in terms of section 10.4, a subsequent marriage was precluded by the provisions of the Recognition of Customary Marriages Act. So, my Lord, if we then go to the prayers that the applicant seeks, it seeks an order that during the entire existence of the marriage, all subsequent customary unions celebrated or entered into were precluded by the existing civil marriage. And that we submit, my Lord, we have established on the cases and on the Recognition Act. So there was no period in South African law where a subsequent union or marriage between two individuals was recognized in the face of a common law civil marriage. One could not enter into as any other marriage. And Lord, and as we indicate in our heads, if the parties elect that the common law will be applied to their marriage, they can't vacillate between the common law and customary law and say, well, for some purposes the common law prevails, in other circumstances customary law prevails. Once they've made an election, they cannot go in both directions. And my Lord, it's a self-same position. If one chooses to get married by customary law under the Recognition Act, one cannot get married to another person by civil law. The Act precludes that. So the position in our law has now been regularized. And my Lord, the reasoning we would submit, my Lord, is that if a wife chooses to enter into a civil marriage with her husband, and use an example where they enter into an anti-nuptial contract, can the husband then, notwithstanding having entered into the marriage and entered into the anti-nuptial contract, then go and enter into a customary union with another wife? My Lord, what would the consequences the proprietary consequences of that second marriage be? And my Lord, there's obviously other consequences which are not only proprietary, which would be impacted by the customary marriage. And my Lord, our submission is that the law is very clear, and the applicant has established a case of it for the relief sought. My Lord, it was obviously my intention before your Lordship found that the validity of the marriages was not an issue before your Lordship. It was my intention to walk your Lordship through the Queen's heads of argument. I don't intend to do that now in the light of your Lordship's ruling, but I would ask your Lordship to have cognizance of the case law and the submissions that we make in those heads in regard to the declaratory relief that we seek. My Lord, if I might just indicate, my Lord, we've relied on the doctrine of election and referred to your Lordship to certain cases in that regard. And my Lord, the respondents suggest, well, the Black Administration Act was a compulsive act, and therefore it's untoward for the respondents for the applicant to rely on the provisions of that act. Well, my Lord, we don't rely on the provisions of that Act to any great extent. But having said that, my Lord, the election that we refer to is the election that the parties made to get married by civil law. Your Lordship has accepted that that is not in dispute, that they elected to get married in terms of the civil law, and thus elected the legal position that would regulate their affairs. Your Lordship will also be cognizant of the fact that during the period...
Okay, let me find out something.
Yes, my Lord.
So the prayers D and E, am I correct, they are no longer pursued?
No, we're not pursuing those, my Lord. My Lord, we abandoned those in our first set of heads of argument. It's, my Lord, those were premised on the... My Lord, if your Lordship will recall the late Queen, the second respondent, passed away. And those prayers thus have not been pursued. And have not been pursued for quite a while, my Lord. So, my Lord, that relief will not be seeking. It's merely the prayers in A, B and C. My Lord, your Lordship will recall that during the subsistence of the marriage and prior to the promulgation of the Recognition Act, there was attempts which were made on the part of the late Asilo to regularize the position relating to his marriages. There seems to be an acknowledgement that there was a difficulty under the common law of him having entered into subsequent customary marriages in the face of the civil marriage. And my Lord, your Lordship will find Annex SWZ 2 SWZ 2.3. A memorandum which was addressed to Cabinet relating to the attempts to regulate the marriages of the King. And my Lord, I'm not going to read it into court, my Lord, but your Lordship will find it's at page 67 and 68 of the founding papers, my Lord. And your Lordship will find at 6.2 that the amendment to the Zulu Code at that stage was the opinion that was obtained was that it did not validate the customary union itself, which was no more than an illicit cohabitation. And my Lord, I've indicated that in fact it was void ab initio. It could never have been in place. My Lord, the argument on the part of the respondents is they suggest that the provisions of the Recognition Act somehow validated the customary marriages. Now the difficulty with that argument, my Lord, is for a start, those marriages were not in existence at the time of the commencement of the Act because they were void ab initio. The Act only recognises valid marriages in terms of the customary law, which were in existence at the date of the commencement of the Act in 2000. It was thus recognising, the Act was intended to recognise customary marriages which were validly entered into in accordance with customary law, which remained unrecognised up until that point. So it recognised all prior valid customary law unions. And I use the term unions because that was the term that was previously used. My Lord, it did not, if the marriages did not exist because they were void, they weren't in existence at the time of the Recognition Act, and thus could not be recognised. My Lord, the difficulty on the respondents' version is, if they are suggesting that as at the date of the Recognition Act, those marriages were recognised as valid marriages, then they would immediately be void, because they couldn't stand side by side a civil marriage. A civil marriage is a monogamous union, and a customary marriage and a civil marriage cannot coexist with different people, just as two civil marriages cannot coexist. And it is the first marriage which must take precedent. My Lord, in the light of my learned friend's contention that they're not dealing with the validity, and your Lordship's ruling that they're not dealing with the validity of the marriage, and the concession relating to that the civil marriage was a valid marriage, I don't intend to address your Lordship on the counter application, because it falls by the wayside, my Lord. My learned friend is indicating that. My Lord, our submission is we've established the basis for the declarator. It's a declarator that we're entitled to. It's a declarator which prescribes the rights of parties. It is a live issue, my Lord, and we've set out in our heads of argument the tests which are applicable to declaratory orders. And your Lordship, this is a matter which cries out for a decision by a court and a declarative in favour of the act. My Lord, if your Lordship finds in our favour in terms of prayers A and B, it would be unnecessary for your Lordship to make a finding in terms of prayer C, because that would by its nature flow from the consequences of A and B. It also, that prayer your Lordship will note, may well be subsumed in the argument relating to the question of the validity of the Late Silo's will.
So if we find in your favor in 2A and B, then the 2C will follow.
The necessity for C will fall away. I'm not certain, does your Lordship take the tea adjournment at 11 o'clock or 11:15?
Quarter past 11.
Half past 11.
Quarter past.
Quarter past. Lord, bears with me. I just want to see if there's any other aspects for Lord. The Lord, perhaps just before I get to the counter, before I conclude on these submissions, my Lord, perhaps I can take your Lordship to paragraphs 121 to 124 of the answering affidavit. Page 408. it's the answering affidavit the respondent submitted, and it's from paragraph 121. They say the following. In these circumstances, according to Zulu customary law, the marriage between the applicant and the applicant queen and the late king was concluded prior to the celebration of the impugned civil marriage purportedly by civil rights. As a matter of law, then, the celebration and conclusion of the impugned civil marriage was an exercise in futility. This was primarily because, in terms of Zulu customary law, the marriage between the two had already been concluded. It is for this reason that King Mr. Zulu has launched a conditional counter-application for a declaration that the applicant queen and the late king were married by customary right prior to 27 December 1969. I support this application as one that is consonant with Zulu customary law.
It's also what happened here. They first entered into the customary marriage and later new civil marriage. What happened?
That was the allegation that was made, my lord. It was disputed.
But the outcome is the same.
My lord?
I say the outcome is the same whether they entered before
Exactly,
or after.
my lord.
It doesn't make any difference.
It doesn't matter, but the argument was that the civil marriage, they didn't recognize. The point I'm making, my lord, is that when this application was launched, the respondents did not acknowledge that there was a civil marriage which was valid and enforceable. That was the dispute. That is the dispute which is on the papers. And that is the reason why we are here, and that is what we understood that was going to be argued. That they've now conceded at the 11th hour. They concede that civil marriage was a valid marriage, and that the consequences of that marriage would.
So against this now is no longer necessary to argue this.
Yes, my lord. It's really to show your lordship that there was necessity to approach the court for a declaratory order because there was a live, hot dispute. The fact that they've conceded that dispute doesn't now entitle them to say, well, now that the dispute is conceded, you're no longer entitled to the declaratory relief. Because if the court does not make a declarator, my lord, they can always raise that exact same point again in the future and attempt to argue that is in fact the legal position. We would be back before another court on exactly the same argument if they. The fact that they've abandoned it doesn't disentitle us to the relief. My lord, just one other issue, my lord, is there's a suggestion that the executor or the master should make the determination as to the validity of the marriage and the consequences of that. My lord, that is not an answer. That doesn't oust the jurisdiction of this court. If there's a live issue which requires determination, my lord, our submission is that is an issue which should correctly be determined by a court of law and not by extrajudicial or extrajudicial.
So was the applicant not required to lodge a claim first with the executor before coming to this court?
My lord, that's another issue in regard to the will, is it not? But in this particular matter, my lord, why would the consequences of the matrimonial regime are something which the applicant is entitled to approach the court to make a determination about. It's not for the executor or the master to make that decision. The master and the master or the executor don't make decisions about the validity of marriages or whether there was in fact or wasn't a marriage. That is a matter which ultimately will have to be determined by a court. My lord, in those circumstances, we would move for an order in terms of prayers 2A and B, of the notice of motion, and we would seek costs of to counsel against all parties opposing this application. Shall I deal with the next application? My Lord, I note it's 11 minutes past 11.
All right, we'll allow the interpreter to summarize for the benefit of those who do not follow the proceedings in English before we adjourn.
Njengamanje ngisaqhubekile lana njengamanje ke zidlala indlala nomthetho nje ekhuzini lodwa lona kodwa ke uma ubuka ke bekhuluma ngoba umuntu manje uyasekela ke manje ke izathu noma ubika amaphuzu ukuthi kungani kufanele kubhekelelwe iliphuzu akhala ngalo ngokwesicelo sakhe sikaNkulunkulu mayelana nokuthi ke nginyaka umshado wakhe njengoba sizokhumbula ukuveza ngokusobala ukuthi ebushadeni kwakhe ngesikhathi ke shadelwa beshada silo ke esisakhuthama ke lapho kuthatha umsebenzi naye umshado abanye babona ke ingobo nobiza ngosilungu ukuthi usebenzi umshado lowo uwona ke okuhlanganisa futhi umshado uhlanganisa ke amafa obese kuthe emva kwaloko ozakwanga wakulandelela ezinye izintokazi bese sezibena emshadweni lo wesintu ukuthi ke inkantolo make igunyazo phela ke manje umthetho ihlukene kathathu noma kaningi manje lokhona udaba lezimshado kunomthetho lo walo mshado wabo okuyiwona ogwema ukuthi owesilisa laba abashadile uma ngabe sebeyifaka kuwona kunomshado ohlanganisayo ukuthi ukwazi ukuthi uphinde uganwe ngale kokuthi umshado uma ngabe ingahlukanisile nalokuthi awukwazi ngakhona omunye umshado ngale kodwa wasekuphelele lokho kokwenziwa-ke inkosi le yakhuthana ngokwentokazi kwaseke uphambili ngokohlobo lomshado ababefake kuwona yilawo maphuzu abasesekela bona ukuthi inkantolo yokuqala iwabheke iwacubungule ukuze ikwazi ukuthi imvume leloko ngoba lapho iwakhona kumayelana phela negunya lakho ukuthi yena njengomdlukulu njengoba inkantolo ike yambuza ukuthi-ke mhlawumbe-ke njengoba-ke lokho kungaphikisiwe phela kukhona izincwadi ey'bhalwe phansi ezivezayo eqinisekisa-ke lokhu ukuthi ngoba ngathi into engayomubhekiswano engaphikisiwe phela khona kubhalwe phansi mhlawumbe-ke kungathi sibe nabo uzodingidwa na akubona nabo mhlawumbe kufanele kuvezwe ngophela laba abanye izintokazi ziyakwazi ukuthi vele zingene kulo mshado kunesimo esikanje ukuthi uma ngabe kuvele kuqondwa kulowo mnyango ukuthi mhlawumbe kubhekwe indaba zamaphuthazi mhlawumbe nanjengoNdlunkulu kunengxenye ethize noma ehlukile kunalaba abanye kodwa kwabo ngokwezamafa nabo usethi cha noma bengazange-ke inhlangathi ephikisayo zikuphikise noma zikuveze kodwa uyabona phela ukuthi lo mbango njengoba-ke ukhitha phasi noma ushubile iwona okulele ekutheni ukuthi size-ke sibe la inkantolo akube yiyona phela manje ezonamula ilamule ngokubanga phela manje-ke icacise noma ikubeke ey'thebeni udaba-ke lakhe-ke uNkulunkulu ukuthi kumike kanjani mayelana nomshado ukuthi ngiyazi ukuthi labo mshado wakhe ilo ngitolo ngiyazi ukuthi akungasavunyelwa ukuthi kube khona amanye amakhosikazi esiko wafanele siwathathe yebo phela kukhona imithetho yaphinde iyakhona endlini kwalo okuyimthetho iyala eMzansi le beyise igunyaza ukuthi-kena owesilisa uma ngabe-ke egana noma ethathwa akwazi ukuthi aphinde athathe amanye amakhosikazi ummeli wakhe uNdlunkulu njengamanje ubesacaphula nakwamanye amacala-ke manje ukuthi-ke kulewo macala ezimo ezingasifana nalezi la kusekunembanga efana naleyo ikuphi inkantolo engakwazi ukuthi ikusebenzise ukuze ikwazi ukuthi imvume ngoba yabo njengamanje-ke usencamulela ugwayi katini inkantolo noma-ke usondeza inkantolo isisombe kuyenga ukuthi ayikwazi ukuthi ibheke lento esho uyena ivune ngasohlangothini kodwa okwamanje saqhubeka siphinde siziyowa sishileyo kodwa ekugcineni kwenkantolo yizethulo ezivulekile inkantolo ekugcineni inkantolo esozomali ukuthi ithini le
Before I forget this, Mr. Redmond,
Mr. Mark.
I want some clarity now because he wants 50% of the joint estate. But according to the document which is taken as the last is a will and the last testament of the late king, the real estate is divided into 5 categories, if I'm not mistaken.
Yes.
I don't know now, but it's not clear to which one, because there's the estate which the king earned as a king, and that part of that estate does not belong to the king as a person. It belongs to the royal house.
Yes.
And there is an estate which he earned as a person, which belong to his personal estate. So it's not clear where this claim is made, whether even that will include that estate is supposed to be belonging to the royal house.
Yes. But my lord, we're not asking you to make determinations and to work out the intricacies of the will and how the estate is to be distributed. We seek the declaratives in A and B, and
that will be determined by
and the parties, because I understand there's also trusts which own properties and there's, my lord, it's whether the estate has been properly distributed or not is something which will ultimately be dealt with. But at this juncture, we're not asking your lordship to enter into that debate. And my lord, and rightly so, more pertinently in the light of what Mr. Topping indicated yesterday, there does seem to be a real question mark over the late King's will of 2016. So it wouldn't be right for us to ask your lordship to make a determination in regard to that.
And we'll take adjournment until 11:30. Are you through?
Lord?
Are you through now?
My Lord, I now intend to embark on the argument on the consensus application.
So you want to get into the second one,
Yes, ma'am.
and the one responding to all.
That's what I understood my learned friends wish to do. The process. I'll argue the
Or we'll
consensus
make it
application.
easier to deal with this one.
My Lord,
You want to respond to what you said?
in relation to the Queen's application,
Yeah.
I can, my Lord.
Yeah, let's deal with the Queen's application so to avoid confusion.
As a cookie.
My Lord, under the broad rubric of the Queen's application, we intend to argue two propositions. The first proposition is that the court does not have to declare or make any declaratory orders, because to do so will amount to a legal opinion and it is unnecessary in the circumstances. That's the first broad principle we wish to argue at the outset in relation to the Queen's application. And in relation to that aspect of the case, we'll emphasize the discretionary nature of the relief. And we would argue that because a declarator is by its nature a declaratory relief, the court has an overriding discretion to decline it, even if the issues it is called upon to declare or to clear up as a matter of law are quite clear in law, and there's authority.
Okay, you move too fast. I was still busy with the first one. Is that the second one?
No, I'm still under the first rubric. That's the first aspect of our case. I will deal with it now in a moment. I just wanted to give you the outline on how our
You
argument
said there are two propositions.
is.
So trying to jot down those propositions.
The first one is that the court should not grant a declarator because it is unnecessary, and I'll come back to that point.
Okay. The second one?
The second one is that even if the court was inclined to consider and entertain an application for a declarator, it should not grant it because it has got no merit and it's misguided in law. In other words, the court should make a decision against the applicant Queen on each of the prongs that underpin the applications for declarator. And those prongs are, firstly, a declarator relating to the regime, the marriage regime of the parties, whether it was the applicant is entitled to 50% of the estate. And the second one,
That is the law.
yes, my lord.
And the law is clear on that. That's all.
Yes, my lord. On that topic, I'll say that. Can I come back to that issue, my lord?
Okay.
The other issue is the preclusion, whether the marriages were precluded. Maybe I should start.
Now is the third one.
Yes,
That conclusion is the third one.
the preclusion is whether the marriages were
Because
all
earlier
precluded.
on you said there are two.
Yes, my lord. The second prong of the declarator is that the question is, were marriages, subsequent customary marriages, precluded by law at the time that they were concluded? I will confine ourselves to the marriage of the late Queen for purposes of this argument.
Okay. All right.
If I may then, my lord, go to the first argument. I should start by saying, and we deal with this, my lord, extensively in our heads of argument, supplementary heads of argument, starting at page 13 through to page 22.
It's page 22.
Page 22, yes, of the supplementary heads.
Okay. Are there any paragraphs?
Yes, my Lord, the relevant paragraph which I would ask my Lordship to have regard to is paragraph 40 of the heads of argument. Which is at page 16.
It's page 22, paragraph 40.
Yes. Where we articulate the reasons why we say that the court should not entertain or make a declaratory order. First, my Lord, when a court is called upon to make a declarator, such as the ones which are sought here, it is effectively being asked to restate the law or to state what the law is. And cases which have been cited in our heads of argument suggest that a court will not readily grant a legal opinion to the parties, because parties can always get that opinion from their lawyers, especially the Queen, who's represented by senior counsel. The court will only do so if there was a live dispute between the parties that the court sought to resolve. So the authorities say that the court will not readily grant a declaratory in the air when there is no live dispute between the parties.
But why do you say that? Because Mr. Redman has said we have just considered before that there was a dispute, is not so?
No, the dispute that there was about the validity of our marriage. There was a dispute about that until yesterday.
Not a dispute about this civil marriage.
Oh yes, no, the law is clear insofar as what is the consequence of a marriage in community of property.
Was the applicant aware of that you had not dispute?
But the dispute which he spoke about is a dispute relating to the pre-existence of a customary marriage. The position.
Well, that the applicant Queen and the King had entered into a marriage in community property, was that an issue?
But what happened is that can I just go back to how the litigation unfolded? What happened? The applicant, we understood at least initially, the Queen applicant, on our understanding, or it was not clear, was attacking the validity of the late Queen's marriage. And then we, in response, said, well, if you are attacking our Queen's marriage, then we are asserting that there was a pre-existent customary marriage. But that issue has died now, because yesterday...
No, what I want to establish, because that's the reason why this matter should come to this court, according to Mr. Redman. Because there was a dispute as to the existence of this civil marriage.
Yes, initially there was, yes. Under the circumstances that I explained.
And that's what brought the matter before this court.
This court. The dispute arose out of the context of the applicant saying that her marriage acquired preeminence above all other marriages. The response of the respondents was, okay, if that is the approach you are taking, please do remember that you had concluded a customary marriage before you concluded a civil marriage. So within that context, there was a dispute. But my Lord, as it happened yesterday, since that issue about the validity of the late Queen's marriage has fallen away, that is no longer an issue now.
So, and you say, therefore, there's no need for a declaration.
There is no need for a declaration, though the law is known. In summary, my lord, we are saying, if you have got no problems, and you are not attacking the validity of any of the Queen's marriages, then of course the issue of whether your marriage was a civil marriage is there factually, and we accept it, and its consequences is known. It has been declared by the Constitutional Court recently in the case of Sitola versus Sitola. The point we are making, my lord, arises at this stage, at this juncture. The point we are making is that even though the law in relation to the consequences of a civil marriage is well known, the court does not have to make that declarator now, in the absence of a live dispute around that issue. And we cite authority for that proposition, which you will find in paragraph 51 of our head of argument, page 20, where we say that while a declarator may be of considerable constitutional importance, a discretion cannot be granted in the air. And declaratory reliefs,
paragraph
51 of our heads.
Okay.
We cite the case of JT Publishing. There's a reference at page 21, case of JT Publishing, where the following is said. I think it was by Justice Didcott in the Constitutional Court at that time, where he said a declaratory order is a discretionary remedy in the sense that the claim lodged by an interested party for such an order does not in itself oblige the court handling the matter to respond to the question which it poses, even when that looks like being capable of a ready answer. A corollary is the judicial policy governing the discretion thus vested in the courts, a well-established and uniformly observed policy which directs them not to exercise it in favor of deciding points that are merely abstract, academic, or hypothetical ones. And I see no reason why this new court should not adopt that rule. So that there is the law set out in J2, that even if the position is clear and it is known, as in the present case, the court does not have to delve into that issue, because there is now, at this point where we are, no real live dispute about that very issue. The reason why this is important, my lord, is because the court is not able at this point to know what the reach of its order will be when the dispute ultimately arises. We don't know what the impact of that order will be in relation to the administration of the estate later on. And this is because in the cases which have come out from the Constitutional Court under the Recognition Act relating to the competing claims against the deceased estate, the Constitutional Court has created a number of court-sanctioned remedies to accord what we call parity of spouses in polygamous marriages. And we see no reason why this court or any other court faced, or even the executor, faced with the barrage of cases which have come out of the Constitutional Court, which I will deal with in a moment, should prejudge that dispute before it even arises. So, my lord, we say it will be a waste of judicial resources for the court to set out the law in circumstances where it is not readily appreciated to what its impact will be, if any, where a dispute was to arise in the future. So, my lord, we say that there is a process that is in place in terms of Section 33 of the Administration of Estate Act on how estates are to be wound up. an executor of the estate who is faced with multiple claims from various spouses should not be faced with a prejudged issue about the status of the marriages, especially in circumstances like the present, where the Constitutional Court has said, with reference to spouses in customary marriages, that they should be equal in relation, the parity of spouses in relation to the deceased estate.
Mr. Madonzela, if you don't, if you accept the the proprietary consequences of the marriage in conflict of property, the wives in customary marriages cannot be equal with that one.
Well, that principle is open to doubt, my Lord.
They cannot be equal.
That principle is open to doubt because in relation to cases which have come before the court, and I will refer to them, one of them is actually referred to now, Lemford's Hayes argument. The Constitutional Court has made every endeavor to achieve what we call parity of spouses in marriages.
What is the
in relation to
that case?
Sir, Malak?
The citation of the
Yes,
case.
Malak, that's the case I was looking for. The case that we are relying upon for this purpose is decision it's paragraph 89 of our heads of argument. It's a judgment of Ramuhovi.
Do you have any relevant page and paragraph?
Yes, my Lord. My Lord, the order itself is set out in paragraph 8, in footnote 82 at page 37.
Paragraph? And then the paragraph of the case itself.
What's paragraph? Paragraph 56.
Okay.
My Lord, I should have started by imposing upon my Lord. We have the authorities, all the authorities referred to in our heads of argument prepared in two liver arch files. I don't know whether it will be.
Please hand them up.
My Lord, may you please hand them up to your Lord.
Right. Please do so. Those only yours.
We refer to almost the same authorities.
So we need a track for this.
Yes. There are no authorities referred to parallel friends which are not in our heads of argument.
That will save us.
My Lord, the copy, the full order granted by the Constitutional Court in Ramahovi, you will find set out in full at footnote 82 of our supplementary heads of argument. That case, my Lord, dealt with the constitutionality of Section 7.1 of the Recognition Act. You'll recall, my Lord, that the Section 7.1 deals with the proprietary consequences of customary marriages. But my Lord, what the court did there was to set up a court-ordered regime that will regulate the dissolution or the devolution of estates in relation to those marriages. And what the court said in paragraph A, if you look at page 37, is that after it declared the provisions unconstitutional, and it said, during the period of suspension of the order, because there was a suspension of the declaration of invalidity, the following regime will apply to polygamous customary marriages concluded before the Act came into operation. Wives and husbands will have joint and equal ownership of rights and joint and equal rights of management and control over marital property, and these rights shall be exercised as follows. And then it set out those rights. And then in paragraph B, it says each spouse retains exclusive rights to her or his personal property. So, my lord, that is now parity amongst customary marriages.
But this case was not only dealing with the polygamous marriages. Does it include the civil marriage?
It was a, my lord, it was a rebooted case of another previous case, which is reported in as Netsutuga. Netsutuga is a case dealt with in the context of a mixture of customary marriages and civil marriages, one of which had been declared invalid.
Yeah,
But you see that
one thing if the court was only dealing with polygamous marriages. But if there's a polygamous marriage vis-a-vis the civil marriage, that's what I want to hear, whether that was the case in the case we are referring to.
my lord, the facts in Netsutuga are quite complicated. What happened is that Netsutuga had approximately 7 wives, well, the ones that are referred to in the heads in the case, and one of them had married Netsutuga, or Joseph, who was the deceased in that case, by civil marriage, and that marriage and some of those marriages had been dissolved by death, others by divorce, and one of them was nullified by the court, the SCA, in 2011. So there was the children of those spouses approached the court in relation to the context in which the court dealt with the administration or dissolution of the estate. So there was a mixture from that perspective of children born out of civil marriage and children born out of customary marriage and even customary wives. So the court said, because these wives were recognized under the Recognition Act, and the administration of this estate should accord with parity of all wives in the estate. So the point that we're making about this, my lord, is that there is a constitutional sanctioned process within which the court seeks to achieve parity between wives, irrespective of the fact that they are in a polygamous customary marriage or civil marriage. That's our point about this case.
Is that what the case says? The case says.
The case, my lord, deals with the declaration. Remember, my lord, Section 7 of the Recognition of Customary Marriages Act.
Let me get this thing clear.
So, my lord,
were the children involved or even the wives?
yes, my lord. The application was actually brought by one of the children.
The children.
One of the children of.
Children are treated differently.
No, my lord, but they were inheriting by virtue of the fact that their mother was married to the deceased by civil marriage.
Yeah.
And their argument was saying the customary wives should inherit the other 50%, because the 50% is one that belonged to our mother.
Well, I follow.
Well, my lord, the point of it is that the complication around the devolution of estates.
So what are you saying now? Are you saying that there should be such an equal treatment in the division of the estate in this matter?
No, my lord, I'm not saying that at this point. I'm saying at this point that it is not, the court should not grant a discretionary remedy at this stage, because the permutation or the effects of the orders that the court may make is unknown in the absence of a live dispute. And the example is the dispute in Ramahovi and Netsutuga. Which,
so are they not also trying to prevent that?
but
By seeking a declaration, are they not trying to prevent that that dispute?
but look, they may very well be trying to that is exactly the problem, to get a prejudgment before even a dispute arises. And that is one of the factors and circumstances under which the court should not grant a declaration, because the court will be prejudging an issue before it even arises. In circumstances where there is a huge amount of uncertainty as to what is a fair and a just process of dissolution of a state. So, my lord, the fact that there are permutations and disputes likely to occur in the future is a militating factor against the court granting a discretion to issue a declarative in the air, as it were. So, my lord, we make the argument that insofar as those declaratives are concerned, the court should not make an order. My learned friends have said in the cases that they have referred to, one of them being Netsutuga, the other one being Ramahovi, the other one being Modise and Monyapela, all referred to a paragraph 73 of our Hezwagin, that the court did not have difficulty in making a declaration in those cases. But my lord, the reason why the court made declaratives in those cases was because the issue of the validity of those marriages was an issue. And the court had to deal with that issue in the context of a challenge, upon the challenge around the validity of those marriages. And that issue does not arise here, because the court has ruled it is not an issue in the pleadings. So the court does not have to follow what happened in those cases and make a declarator, because there the dispute between the parties was known and all the papers were clear and complete as to what the dispute was in those cases. Here, the court is venturing in an area which it is not even sure who is going to be a claimant in the estate. And that is an issue that the executor or each of the wives or even the applicant can lay a claim against the executor, and only when the executor seeks to deviate from what the legal position is can the matter then be declared by the court. Not before then. So, my lord, we submit that the court, in the absence of those live issues, and in the absence of any attempt by the executor of the King's will, or late King's will, to act contrary to what the law is, the court should not preempt that dispute and grant an order that will shackle the executor from doing what is just and fair, and to exercise her powers or his powers in terms of the administration of the Estate Act. So, my lord, we say that as we articulated in our founding affidavit, or composite answering affidavit, we said, my lord, the issue is premature.
Okay, I think you have made your point. Move on now.
Yes, move. On the other topic, my lord, we say there is an attempt in this case by the applicant to invoke the provisions of Section 22 of the Native Administration Act. My lord, may I ask the court to go to the Queen applicant's supplemental or revised Hays of argument?
What volume is that?
The Queen's Heads of Argument, it's page 16. Queen's Heads of
16.
Argument.
Is page 16 of volume 1 or page 16 of the...
But in the Queen's application, I intend to, in the Queen's Heads of Argument,
These are not in that, so... Are you referring to her founding affidavit?
no, I'm referring to the Heads of Argument.
I can't find
The
it.
applicant's Heads of Argument.
Carry on now, just note to us.
But I can read out what the Heads of Argument say. And this is consonant with the founding affidavit of the applicant Queen on this court. Paragraph 50 of those heads at page 16. The argument advanced by the applicant Queen, or advanced on behalf of the applicant, is that the applicant, that is the applicant Queen, and the late Isilo were married in terms of the Black Administration Act, read with the Marriages Act. And both these acts catered for a single marriage between two individuals and did not recognize or allow a polygamous marriage. And then paragraph 51 goes on to say the provisions of the BAA, the Black Administration Act, relating to marriages was contained in section 22.1, read with subsection 22.3, and it quotes the provisions of section 22.1, where it says, no male native shall, during the subsistence of a customary union between him and any woman, contract a marriage with any other woman unless he has first declared upon oath before the marriage or native commissioner of the district in which he is domiciled the name of every such first mentioned woman, the name of every child, and any such customary marriage union. So, my lord, in the first point we wish to make on this point is that there is an invocation of the Black Administration Act in this regard. It's foursquare reliance on the Black Administration Act to sustain the conclusion or the argument that there was a blanket preclusion of black couples to marry each other in the presence of civil marriage by any other form of marriage. My lord, with respect, the text of the section that I've just read does not sustain that argument. And as I will show now, the Black Administration Act in fact permitted coexistence of marriages among black people. It permitted it under the only constraint for a black person to marry a second wife related to making certain declarations before the commission. That was the law in terms of the Black Administration Act.
For what section was it?
Section 22.1. My lord, this is against popular belief, but it's true as a matter of law that there was no preclusion for black people to marry polygamous marriages even under the regime put in place by the Black Administration Act, at a particular point in time.
But
And-
this one was married under Marriage Act.
Well, the Marriages Act also did not have any specific provision that precluded black people from marrying marrying other women. And the applicants indeed cannot point to any specific provision of the Marriages Act because none exist. We've read the Marriages Act, and we reflect the position insofar as that is concerned, my lord, in our heads of argument. What the Marriages Act did in the system of regulating black people or regulating marriages was to impose constraint on a marriage officer in solemnizing marriages. It has prohibition about solemnizing marriages between people of certain ages or young ages. It had prohibition against marrying people who are black and white. It had prohibition against all sorts of categories of prohibitions. But it did not have a specific preclusion forbidding people to marry each other polygamously. So, my lord, it is not correct as a matter of law that black people were precluded by any of the provisions of either the Black Administration Act or the Marriages Act to marry after they had married another spouse by civil right. What there were constraints under the BAA to make certain declarations. Under the Marriages Act, the constraints were placed upon the solemnizing officer not to solemnize marriages under certain circumstances. The position at common law and the position and the posture taken by the law at that time was consistent with the times in which we lived. What the common law how the common law looked at customary marriages was certainly because the reason why they were not specifically regulated is because the common law regarded customary marriages as not marriages, but as unions.
But I think we are nearly exhausting your 45 minutes.
Yes, my lord. And because my argument is just there. I've just made the argument.
You have to wind up your argument.
Yes, my lord. So, my lord, I'm saying that if the court was keen on engaging on the issue of a declarative relating to the argument about preclusion, you will find no authority for the proposition that there was a preclusion in the time, between the time from 1922 up until 1988 for the preclusion of marriages, of multiple marriages under the Black Administration Act or the Marriages Act. And that is because the law of the time, the common law, did not regard customary marriages as marriages. That was the posture of the common law. So, my lord, the only prohibition came in 1988. And we set out the three phases of the legislative reform at paragraph 61 of our heads. We had the first phase where there was no prohibition, no preclusion. And the second phase was the post 2 December 1988, where then there was introduced a prohibition or preclusion of marriage being concluded. And then the third phase, which we referred to at paragraph 63, is the post 2000 position under the Recognition of Customary Marriages Act. But because in this case, insofar as the late Queen is concerned, her marriage with the late King was concluded on the 22nd of July 1977. You will see this at paragraph 143 of the composite answering affidavit, page 415, volume 5. Because they were married to each other by customary marriage in 1977. Before 1988, their marriage was regulated by the pre-1988 regime, which had no preclusion or prohibition of African people or black people marrying any other spouse by any other regime, especially customary marriage union, because the law at the time did not preclude it. It only closed its eyes to the customary unions which existed between black people. That was the fourth line of the common law. Now the question here in this case, if I can just wrap up on this argument, is whether this court should reenact the legislative or the common law position by making a declaration as to what the law was then, ignoring the customary marriage as if it did not exist as a matter of law. And our submission is that the court cannot do so today. Firstly, because there was no preclusion, but the court cannot reenact the common law as it stood at that time, because that would be against the dignity of the queens who married the king before the 1988. Of course, the position was different after 1988, because the 1988 regime provided a specific prohibition, and that prohibition is seen when you read the act itself. When it was amended in 1988, the law read differently, and it said, a man or a woman between whom a customary union subsists are competent to contract a marriage with each other if a man is also not a party in a subsisting customary union with another woman. There was a specific prohibition only in 1988. And the cases which my learned friend is referring to for the proposition that you could not have a coexistence of a civil and customary marriage are all cases which are decided with reference to marriages which are concluded after 1988. And indeed the authorities to which he refers, the old authorities which he refers, are authorities, including Bennett, are authorities which reflect the position as it were after 1988. But in a revised version of Bennett, Bennett reflects on this reality. At pages which are referred to in our heads of argument, we refer to these passages in our heads of argument. You'll see this being dealt with at where is that here? At page 34, paragraph 8 of our heads of argument. The posture of the common law was this. You had a situation where if you married a person in terms of the civil law or civil rights, and then attempted to marry a person in terms of customary law after the civil marriage, the common law posture was that union is not a union. What the man in the civil marriage has done, he has deserted the wife. That was the posture of common law. So that marriage was not regarded as a marriage. In the eyes, it will only provide a spouse in a civil marriage with a remedy to sue or to ask for a divorce and repudiate and ask the husband to repudiate the desertion. But if the facts were turned around, a man was married in a customary union to a woman and subsequently tried to marry another woman by civil rights, the posture of the common law was that the marriage which was concluded before was discarded ipso jure and without even a court order or nullification order. That was the posture of the common law. Because the common law did not regard those marriages as marriages, they were referred to as customary unions. The question that confronts this court today is, should this court, under the guise of the declaratory being sought now, reenact that legal position in the present day situation? We say no. We say no because the court struck court in Alaska reflected on what the approach is when the court is called upon to reenact the law that was in existence before the Constitution came into effect. And we set out that the approach to that request for a declarator in the passages which are referred to at page 31, paragraph 74 of our heads of argument, page 33. The position is that
You said you were wrapping up.
Wrapping up, my lord. So, my lord, we say the court should not make a declaration regarding. There was no preclusion. Firstly, there is no life dispute. Secondly, there was no preclusion, especially of the late Queen and the late Isilo to be married to each other in 1988, because the law at that time permitted coexistence. So, my lord, when you are referred to in all the authorities, and we dealt with all of them at paragraph of our heads on paragraph, is that those authorities were decided after 1980. So, my lord, we say that.
What we do now, your Mr. so that you reply to both. Mr. Topping, are you through?
I'm done.
Okay. Thank you. Mr. Topping, I think he has covered a lot, and you.
He has, my lord, and
He's just filling the gaps.
I'm not filling in the gaps. I'm supporting up my learned friend at the level, my lord, as I've said before. We support what Mr. Madansela has submitted before you, and we also align ourselves with the extensive arguments set out in the heads that have been placed before you. But all I want to emphasize is encourage you to exercise your discretion against granting the two declaratory orders that are now pertinent before you, because, my lord, they will have no effect and there will be no consequence following from it. The court doesn't grant an order, as my learned friend has pointed out, in the air or in a vacuum. If one looks, my lord, at the first, or both A and B, my lord, if one looks at C, which has now been abandoned by my learned friend at the level of no relief is now sought at a direction as to what the master ought to do as to the winding up of the estate. The first two declarators were sought with an eye on the winding up of the estate. And my lord, that's a long way away, and I'm confident all of us will be before you in months to come arguing how the estate should be wound up, but it's not before you now. Now, looking at that in context, my lord, the declarator A is it's sought that is declared that the marriage is in community of property. Now, my lord, that declarator, as I've pointed out, was already made by this court, by you, my lord, in January of 2020, before these proceedings were instituted. That was the law, that a marriage concluded subsequent to the provisions of Section 22(7) of the Black Administration Act was a marriage in community of property. So there was no need for such a declaration. There was no dispute at the institution of these proceedings, and there's no dispute now. A dispute arose and has now subsided because that's been conceded on the paper. So at the institution of these proceedings, my lord, the law was that the marriage concluded between the later Silo and the applicant queen was one in community of property. So at that level, my lord, there's no consequence following from that declarator that if you make it now, and therefore, my lord, one ought not to make it. And my lord, going further forward, the declarator sought in paragraph B is one declaring as to events that happened in the past. Now, my lord, with great respect, a lot of water has gone underneath the bridge since then. The declarator in essence says, or seeks you to declare that the later Silo was precluded from entering into the subsequent marriages. Now, my lord, we all know the subsequent marriages were entered into. So in other words, your declarator now, and the applicant queen has sat idly by since 1969, and let all these marriages take place. She now seeks after the law has changed drastically, a declarator as to events or a preclusion of events, going right the way back to the 1960s. So at that level, my lord, there is no consequence following from that declarator, because you are in essence saying to the late Asilo, you are not allowed to get married now, but he's knowing full well that he's already been married a number of times. So, and we go following through, my lord, taking now the Recognition Act, those subsequent marriages, if concluded consequent upon the provisions of the customary law, are valid marriages and recognized. So virtually the declarator goes back full circle. In other words, asking you to declare that they're not allowed to do something that he's already done, which is already recognized by law as we stand here now. So again, my lord, absolutely no consequence will flow from that order, and it's not appropriate for your lordship to grant such a declarator in these circumstances.
So are you saying that recognized even if they were contracted or entered into during the subsistence of a civil marriage?
Well, where we are now, my lord, we don't know. Because it's not before you, we're dealing now, that question arises to the status of those marriages. And the status of those marriages are not before you. So we have to look at it in isolation and look at it what's before you on these papers. Now, the declarator is sought not with an eye on the, well, it was initially sought with the eye on the division of the state, it's no longer there. And it's not sought with the eye on a declaration of invalidity of those marriages. And that makes it even more in a vacuum. Thank you, Lord. I've noted this.
Thank you. Mr. Redman, do you have any reply?
Yes, my lord. Couple of things. My learned friend for the Queen suggested, my lord, that the law has changed drastically since the King's marriage. With due respect, I've shown your lordship that the law is exactly the same. It has always been and is still the position that if one gets married under the Marriages Act by civil law, one cannot then consummate any subsequent marriages, whether by customary marriage or by civil marriage. That is the law. It was the law in 1969. It is the law today. Today it's contained in section 10.4 of the Recognition Act, which specifically states that. Okay. As my learned friend for the second respondent conceived in 1988, it was specifically regulated in terms of the legislation. Prior to that, it was specifically regulated in terms of the common law. The Marriages Act has always understood a monogamous marriage, and my lord, we refer your lordship to the case of Medise, which is contained in the heads of argument, and I need only refer your lordship to paragraph 24 of the judgment of Medise versus the Master of the High Court. And it's paragraph 24, a civil marriage is monogamous in nature. It is formally recognized union of two peoples as partners in a relationship, in a personal relationship. And there, my lord?
But what's the reference there?
It's the judgment of Medise versus the Master. And it's the first judgment contained in our heads of argument.
Okay.
And it's a judgment of His Lordship, Mr. Matajani. My lord, that has been the law, that has always been the law. Is there a live dispute, my lord? My learned friends ask your lordship, don't make a determination in this matter, rather duck the issue. Don't make a determination, because we can deal with it later. We will address it later and we'll argue over it at a later stage. Let the matter be dealt with in due course. Well, with due respect, my lord, the fact that they tell you that and they indicate that there is in fact a dispute, which they have to concede, my lord, because they've been arguing on their feet for a period. They know there's a dispute relating to this. And it's a dispute which is a live dispute which needs to be determined. The determination of this dispute will go a long way in preventing further or future litigation on this exact same matter. My lord, in regard to declaratory orders, The court should not be supine and sit back and allow live disputes not to be determined. Yes, the court does have a discretion, but that discretion must be exercised judicially. If I might refer your lordship to our heads of argument where we refer to an extract, my lord, from the Constitutional Court dealing with the question of declaratory orders. It's at page 100 of our heads of argument. The Rail Commuters Action Group versus Transnet, the Constitutional Court described the position as follows. It is quite clear that before it makes a declaration...
The citation is Transnet.
My lord?
The citation of the case?
It's Rail Commuters Action Group versus Transnet. The extract that we've referred to, my lord, is found at page 410 of the judgment, my lord. It is quite clear that before it makes a declaratory order, the court must consider all the relevant circumstances. A declaratory order is a flexible remedy which can assist in clarifying legal and constitutional obligations in a manner which promotes the protection and enforcement of our Constitution and its values. Declaratory orders, of course, may be accompanied by other forms of relief, such as mandatory or prohibitory orders, but they may also stand on their own. In considering whether it is desirable to order mandatory or prohibitory relief, in addition to the declarator, the court will consider the relevant circumstances. And the relevant circumstances in this matter are that the parties have reached a deadlock in regard and have come to blows in regard to the disputes which have arisen in this matter. And our submission, my lord, is that this is not a matter where the court should duck the issue. My lord, my learned friend, the second respondent and others, suggests, my lord, that the position under the law prior to 1988, there was no legislative prohibition against a customary and civil marriage living alongside each other with different persons. Well, my lord, what your lordship will note, first of all, my learned friend has ignored all the judgments. He's ignored the authorities that we've referred to, and he has to, Lord, because they specifically state that the civil and customary marriages could not stand alongside each other. One could not enter into a customary marriage or a customary union in the face of a civil marriage. That is our case, my lord. Our case is that was never part of our law. Once one had concluded a civil marriage, one could never enter into a customary or any other marriage, my lord. And I have reiterated and emphasized that point, my lord. My learned friend referred to certain cases, my lord. The first one being, I think it's a Ramahobi matter. And my lord, my lord, your lordship, if I might, that judgment, my lord, there was dealing with section 7 of the Recognition Act, my lord. And in that, subsequent to that judgment, my lord, and in accordance with that was a challenge to section 7 of the Recognition Act, because it related to polygamous marriages, not civil marriages, but polygamous customary marriages, and the Constitutional Court declared certain provisions in section 7 unconstitutional. Subsequent to that judgment, my lord, the Act was changed. The Act was amended to incorporate the recommendations of the Constitutional Court. So those issues have already been resolved. There was a challenge to the Constitutional Court. It doesn't impact us. It's irrelevant to the determination of this matter. My lord, in the matter of Inshituku, the ratio of that judgment, my lord, is that That's Inchituku versus Inchituku. The ratio was that where there was a customary marriage which had been concluded prior to the conclusion of a civil marriage. But the customary marriage was in accordance with the provisions of the Recognition of Customary Marriages Act. And there was then, subsequent to the customary marriage, there was an attempt by the husband to get married civilly to another person. And the court declared the civil marriage to be null and void. And rightly so. The two matrimonial regimes cannot live side by side. And that is a judgment, my Lord, of the Supreme Court of Appeal. The Supreme Court of Appeal found that the second marriage was a nullity and was null and void. And my Lord, in essence, it's on par with what we say, only to the effect that two marriages cannot live alongside each other, one being civil and one being customary. My Lord, just one issue. My learned friends, relating to the marriage itself, my learned friends suggest that because they have now conceded that there was a marriage, and they've now conceded that the prior customary marriage didn't prevent a civil marriage being concluded by the Queen, therefore there's no live issue before this court. I've made this point, my Lord. The fact that they conceded the relief, after having vociferously argued it and raised all the issues, doesn't mean that we are now, because they've conceded it, we're not entitled to the relief. My Lord, our submission, because they can raise it again, they can dispute it at a later stage. Our submission is, my Lord, we have established a case for the relief sought. And I've moved from the order together with the process. That's complete.
inqume mayelana nodaba lokuthi ngoba okuyikona kona noma mbango manje ovezwa noma ke ukhunyelwa ke iyona indodakazi enkulu mayelana nokuthi yena ngokohlobo lomshado oshadile akagunyazwe ukuthi phela azokwazi ukuthi efeni akwazi ukuthi athole leyo isigambo lesefa noma ngisathi lo-50% njengoba phela imishado ke ingafani ngoba leli phuzu lokuthi lena eminye imishado mayibhuduze njengoba beze kakuke emveni koba eseshado kuhlola umshado ukuthi cha akuseyona umpikiswano kulokho kodwa inkantolo mayigunyazwe ekutheni phela ubhekelele indaba lomshado nanokuthi futhi inkosi la noma lesilo lesisaphothama sasingafanelekile ukuthi ke sasingaqhubeka nokuthi ke sicacele masiphindele sishadelwe ngabanye ke onkulunkulu ngenxa yohlobo lomshado abavezile ilezi zathi ezilandela kona zibeka futhi uchaze ngoba ukuthi nesizathu sokuthi kubuya sengazathi lesi sicelo sesiyaphuthuma noma sisheshile ngoba la kusazokhulunywa udaba lamafa okusho ukuthi manje inkantolo mayiqaphele futhi lokho ukuthi uma ngabe ikhuthuma ke kuba khona isinqumo ezosithatha noma ezokusho ngalokho ibheke phela umthelo ngoba nalapha ke ucace ukuthi uma ngabe sekukhulunywa ngezamafa ukuthi ubani ufuna athole lokho ekubeni futhi ungasona kungayona inkantolo efanelekile noma okwamanje akulona udaba esinida ngani noma mhlawumbe okwamanje sisakhuluma ukuthi ngefa incwadi yefa yayibhalwe bani yayithini kodwa bekusakhona nje ngodaba lokudinga ukuthi ngokwandlunkulu ukuthi cha phela mina umshado wami uhlukile ma uthathwe ngalolo noma inkantolo ibe nalokuqinisekisa ukuthi umshado wami cha yena beshada ngalohlobo lomshado ekubeni abanye uNkulunkulu belandela lokho bengashadanga nohlobo lomshado wakhe futhi ke phela inkantolo ayiqaphele ukuthi sizokhumbula ukuthi ngaphambili kwawona umshado nje ngokomthetho okhona ngaleso sikhathi ngoba uNdlunkulu isikhathi-ke ashada ngaso lapha ngomhla 27 kuDisemba ku-1969 kwakunemithetho eyayisetshenziswa ngoba siphila ngaphansi kwemithetho ebakhona izikhathi nezikhathi nanokuthi futhi kwakona lo mthetho oshayiwe ubhekwa emthethweni wabantu abamnyama kwezokuhlanganisa noma kwezokugcagcela into nje ebengathi ngazi ukuchaza ukuthi umshado noma ukugcagcelwa bengathi into ebengekungabikho emthethweni noma ngokwezincwadi kodwa uye kwahamba-ke kuthe lapha-ke ngo-1988 kwakhona futhi eminye imithetho esiyivezwa yokugunyaza noma eyayiguqulwa ngoba siyazi ukuthi esikhathini sangaphambili bekungashadwa nje ngale ukuthi umuntu uyashada bekumbala imithetho mhlawumbe owebala elithize akakwazi ukushada nowebala elithize nanokuthi bekunezinto ebekade zichaza ebezihambelela ngoba namanje kulesi sikhathi sesiphila kuso-ke manje sesiphila ngaphansi komthetho osisekelo kuwona-ke ogunyazayo ezinye zezinto zempilo osekuye nezinguquko eziningi nanokuthi futhi phela khumbula ukuthi njengoba manje-ke sekunalo mbango osushisa phansi akuyona into eyenzeka izolo le indaba zokucacelwa vele abanakwabo noma abanondlunkulu ngisho kanjalo bangena ngapha-ke esigodlweni noma kuNdlunkulu nolunye njengoba bezolekela khona beloNdlunkulu ngaphambilini kubenesikhathi sikhuluma ngomshado eseneminyaka okumanje inkantolo esingakwazi ukuthi iyoguqula iyohlehisa umlando wangalesa sikhathi ubekile nje badonsela ukuthi cha yena nje ubona ukuthi inkantolo uma ubheka ngokohlobo lesicelo esithasafakwa nanokuthi-ke uma ngabe inkabi lingenelela ungaba namthelela muni la kuloko ngoba phela manje uma sibheka lo mbango ngendlela ushisa phansi umbaqambile noma kuningi okunye okusavezwa phela uma ngabe ngakuthindrana incwadi yefa naye okucacile ukuthi ingaba nakuthi kube ukuphikiswana nezinto ezithize ngoba kunezicelo zahlukahlukene kungcono kona ukuthi okwamanje ayingagunyazi ngoba phela vele akuphikisile ukuthi uNdlunkulu ushade ngalo hlobo lomshado ashade ngalo kukhona into ebhalwe phansi kodwa sikhumbule phela ngoba uyabona uma ngabenza izethulo zabazi bacaphuna kwamanye amacala angaphambilini ukuthi uyazi kunelinye icala ngoba inkantolo nayo iyacaphuna elinye icala nje elisandokwenzeka ngoba uma sesikhuluma ngefa kube kunesithembu kuba nombango la kusefuna ukuthi inkantolo zingenelele khona ukuthi kuningi amacala ecashiniwe ukuthi kukhona icala elisandokwenzeka lombango kuwukuthi bashade imishado engafani ehlukene njenganalolu daba esiphambi kwami kodwa ekugcineni ngokomthetho othe wasetshenziswa wabe usubalinganisa bonke ukuthi uyabona ngoba vele sonke sidle isitshebo esisodwa singabantwana bomunye umuntu akulinganiswe-ke zonke-ke izinto ngendlela efanayo yikona kobe kusavezwe-ke kanti-ke omunye naye osohlangothini lokuphikisana ungezelelile nje bese shayelela nje sifikile lokho kusho kwamadoda okuqala ngempela-ke afike njalo inkantolo ayingakhamazeli noma-ke ayingabuki ngeso lalesicelo samanje sithe safakwa kodwa-ke kube kukonke nalezi zinto ezingami ukuthi ingasheshi ngiyazisa ngoba kusho phela manje uma kukhona isinqumo ezosithatha noma mayelana nalokhu yona isiyoguqula umlando noma into eyayenzeke ngaphambilini ngaphambi kokuba sibe kulo mthetho-ke esikuwo ekubeni vele le mishado kungaseyona into esiyiphikisile nayo le mishado elama uNdlunkulu lezi ezinye izindlovukazi nazo phela zithathwa njengesishade ngokusemthethweni kanti bese phendula futhi ummeli-ke kaNdlunkulu waveza izathu zakuthi ngempela usagcizelelile ukuthi asikhumbule phela ukuthi umthetho ngendlela seyibeka ngakhona inhlangothi ephikisayo sezithatha njengazathi umthetho into eyayingekho ngaphambilini noma-ke kudala into eseyikhona manje umthetho ubuvele ukhona phela kwangalesa sikhathi ngo-1969 kwakuvele kunomthetho kuphilwa ngaphansi kwawo njengoba namanje siphila ngaphansi kwemithetho lo mthetho akhuluma ngawo yena ekugcizeleni ukuthi hayi inkantolo mayimuze usisekahle ngempela ngoba beseshaya isifiko sokugcina ukukhonkotha enkantolo ngizwe kulokuthi ngikushole ngiphethe nginanamacala engicaphuna kuwona angifakazelayo ukuthi umthetho lo womuntu uma ngabe eshade ngohlobo umshado oshade ngoNkulunkulu lo hlanganisa amafa uyagunyaza ukuthi phela kufanele yena okwakuhluke ingcenye ke yakhe ngenxa yolu hlobo lokuphila yena ube nalo futhi sonke lesikhathi abanye bebeshade ngenye ke ingcenye kodwa besika nje kwejikayo konke ke kulele ke kwinkosi enkantolo ke izokusimuka emva kokulala izithuko zami ezakhona.
Well, let's bring us to the end of the first case of the African Queen. We now move on to the case of the Princess Tando Ngozi and another.
Thank you, Lord.
Yes.
Kakhuphi-ke nje okwamanje-ke ukuthi emveni zonke lezi thulo manje inkathi bezochaza noma ke lo sekwenza ukuthi ngoba sinecele ehlukahlukene sesizondlulela phambili manje ukudlela udaba olufakwe abantwana ke laba
This revolves around the will.
Yes.
In the last testament and the disputes of fact. And
Yes, my Lord, we're not asking your Lordship to make any determination relating to the will. That's an issue which, it's indicated on the papers, that will be something which will be determined at a trial in due course. So,
okay.
so my Lord, I will take your Lordship to the relief that we seek here. It's interdictory relief that we seek in this application.
Okay.
My Lord, might I immediately state, my Lord, this matter is not about the determination of the succession to the Zulu throne. Your Lordship is not required to make that determination. I know my learned friends' heads of argument, they say that the primary issue for determination by this court, and they suggest this in both applications, my Lord, is the succession to the Zulu throne. And they implore, my Lord, that your Lordship should make a final determination as to the succession to the throne. Well, with due respect, that is not your Lordship's function and is not something which your Lordship is required to do in this application.
This is not sought. This is also not something sought in these papers.
My Lord?
That the succession is not an issue.
It's not an issue your Lordship need determine, my Lord. Your Lordship is not asked to make. That is a decision that has to be made by the royal family in accordance with the provisions of customary law and in accordance with the Khoisan and KZN Act. It is not something that your Lordship should interfere with and should get involved with at this stage. My Lord, if I might take your Lordship to my head, I want to just emphasize that, my Lord, that you're...
So now, what are you arguing? Arguing the interdict?
An interdict, my Lord. We're seeking an interim interdict. My Lord, if I might take your Lordship to...
Let me get this thing clearly.
My Lord?
Let me get clearly.
Yes.
There's 2.1.
My Lord, might I take your Lordship to page 197, the amended notice of motion.
197.
197, my Lord, it's in volume 3.
Yes.
My Lord, your Lordship can ignore paragraph 1 because the urgency has been dealt with. Paragraph 2, that the applicants be granted leave to amend the notice of motion. I would submit, my Lord, that there can't really be any objection to that at this juncture. And then it's paragraph 4, my Lord. And my Lord, it's formulated in the form of a rule nisi, but obviously in the light of all the papers having been exchanged between the parties and the fact that the matter is now before your Lordship, we would submit that it's not necessary to grant a rule nisi. Your Lordship can grant an interdict in accordance with the prayers that are sought. Your Lordship will note from prayer 4.1 on page 198, it says, pending the final determination of the action to be instituted by the applicants herein relating to the validity of the last will and testament of the late His Majesty King Goodwill Zwelithini Zulu, and the final determination of the relief sought in Part B of this application. A. The execution of the will of the late His Majesty King Goodwill Zwelithini is suspended. Now, I want to just pause there, my Lord. We would submit that there can't really be any opposition to that particular aspect, because the parties are ad idem that there's a material disputed fact relating to the question as to whether the will is or isn't the hand of the king. And in the light of that dispute, my Lord, we would submit there can be no basis on which that will should be implemented at this stage.
So
until
the question resolves itself there.
Yes. Yeah. We would submit that release should immediately shouldn't be opposed. Then B, the seventh respondent, B and is hereby interdicted and restrained from performing any functions or duties assigned to him in terms of the provisions of the last will and testament. Similarly, my Lord, he shouldn't be the executor. C, the ninth respondent, be interdicted and restrained from recognizing or undertaking any steps which may reasonably be construed as recognizing the 12th respondent as Isilo AmaZulu. That is a hotly contentious issue, and I will address that, my Lord. D, the ninth respondent be interdicted from announcing the date of the coronation of the 12th respondent as Isilo AmaZulu. E, in the event that the ninth respondent has completed all processes envisaged in Section 17 of the KwaZulu-Natal Traditional Leadership Act and Governance Act of 2005, the 11th respondent be interdicted and restrained from issuing the certificate of recognition of the 12th respondent. F, the 12th respondent be directed in terms of the Section 9.3 of the Traditional Leadership and Governance Framework Act to refer the matter of succession to the throne as Isilo AmaZulu back to the Zulu Royal Family for reconsideration and resolution. And then, my Lord, paragraph 5, part B, to the extent that certain actions were actually taken which constitute the implementation of the last will and testament of His late Majesty King Goodwill Zwelithini. 5.1, it is declared that clause 15 of the last will and testament of the late His Majesty Goodwill Zwelithini is ultra vires, the provisions of section 17. I do not intend to persist with that rule.
Okay.
2, to the extent that clause 15 of the will is declared invalid, it is declared that the late Her Majesty Queen Mantombi Shiwa Dlamini Zulu has no title to bequeath or nominate through her last will and testament the 12th respondent as successor to the throne. 5.3, and my Lord, I want to take some instructions, but I don't believe that is necessary in the light of what is
Okay.
to the extent that the late Her Majesty Queen Manfombi Shiyiwe Dlamini Zulu purported that she was the regent and through her last will and testament dated 20 April nominated and appointed Prince Mr. Zulu as a successor to the throne as Isilo AmaZulu, it is declared that such nomination and appointment is ultra vires section 17. I also don't intend to persist with that.
Yes.
The primary relief that we seek, my Lord, is twofold. The first, my Lord, the first is the simple interdictory relief preventing the implementation of the provisions of the will until the will has been finally determined as to whether it is or isn't valid. The secondary relief, my Lord, if I might call it that, is the relief relating to the determination as to who should be the king upon the determination by the royal family of that. It's the interdict that's been sought against any coronation or succession to the throne pending the finalization of the issue relating to the will.
So do you still pursue F? That section is going. or is for an F as well?
My Lord, my instructions are to seek an order in terms of F as well.
Because now we start struggling over now to succession.
My Lord,
Or maybe I'll give you time during the lunch hour to sort out which one we are still pursuing with.
whether we're
which one.
seeking F, that's a good, please.
I think that'll be appropriate because now it's trying to shoot out some routes. So I want to know where each route starts and ends.
Yes.
Okay, today I think I'm right now. I'm reading time. Am I right or wrong? What's the time now?
1 o'clock.
It's 1 o'clock. So I think so that we'll be able to finalize this matter. We'll adjourn until 2 o'clock.
That's good, please.
Got a chance?
Sorry, Father. Some sort.
Yeah.
Hey, that's what you say.
D and E, my lord.
D and E.
Yes.
But we are not saying, are you not saying that it is, we are not seeking,
We're not?
we are not seeking E
We're not seeking, no, we're not seeking F, my lord.
or F.
I apologize if I said E. It's F we're not seeking. We're seeking A to E.
And in 5,
My lord, at this juncture, we're not proceeding with Part B.
okay. So it's A up to E.
Yes, my lord.
Open then you may proceed.
Thank you, my lord. My lord, might I take your lordship to my heads of argument? I will go as quickly as I can. I'm cognizant of the fact that we've got short time periods to deal with this issue. I will deal with it as quickly as I can. My lord, my heads of argument, if we could start at page 11 of my heads of argument, and it's the heads of argument, consolidated heads of argument relating to the princess's matter. My lord, in paragraph 31 through to 35, I demonstrated the facts upon which this application are based are relatively straightforward. There are no real disputes of fact, my lord, and they are set out in the answering affidavits and the founding affidavit. My lord, on 12 March 2021, the late Sila passed away. He was interned on the 17th of March. On receipt of the impugned will, Princesses on the 24th of March appointed a handwriting expert to analyse the signatures which appeared on the pages of the impugned will. On the 19th April 2021, the handwriting experts delivered his report, and arising from that report, this application was then launched. My lord, the respondents have raised a number of issues in opposition. I have set the opposition, the defences raised by the respondents out in paragraph 38 of my head, and I address them further on in the affidavit. My lord, the full chronology of the events then continues at page 14 of my heads of argument. And your lordship will note that there was a meeting held on the 30th of March 2021 where the late Queen Dlamini Zulu was purportedly identified by the royal family as the regent. Your Lord, your lordship will note from the impugned will, and I might take your lordship immediately to the will, my lord. It's found in volume 2 of the Princess's application. It's NZ3. Page 116.
Page 116.
116, my lord. And it goes through to page 122. is significant. Is your Lordship with me?
Yes, what is the
116, my Lord, is the will, and if your Lordship pages then through to page 120, I have referred to the will to in my argument relating to the Queen's matter, and referred to your Lordship to certain references made in the will. And I now refer your Lordship to paragraph 15 on page 120. Your Lordship will see at paragraph 15, there's a reference that says, as regards my successor to the throne, I hereby nominate and appoint SM Zulu, identity number 5, and there's a manuscript amendment,
is it paragraph 15?
5102, and there seems to be a signature underneath that.
Is it paragraph 15?
Paragraph 15. Now, the identity of SM Zulu, my Lord, is the identity of the late Queen, Dlamini Zulu. Now, my Lord, there's obviously, or I say obviously, my Lord, there was some question mark over the amendments on this page, as well as the question of the signatures on the will, as to whether they were in fact that of the later sealer. My Lord, this application was launched. It was set down initially for the 7th of May 2021. Your Lordship will recall that significantly that was before any meeting of the family had taken place, or the identity of a future king had been made. This application was launched, and there was a challenge to the will. My Lord, on the 7th of May, sorry, my Lord, before that, on the 29th of April, the late Queen passed away. And that your Lordship will find at 39.8 of my heads of argument. My Lord, these are all common course facts, the chronology. On the 7th of May, in the same day when the application was set out, the will of the late Queen was read together with a letter wherein she purported to have written to Prince Buthelezi and the family on the 23rd of March 2021. That is contained in paragraphs 45 and 46 of the founding affidavit. And that your Lordship will find at page, so it's in the answer affidavit, page 220 to 221. My Lord, it's then alleged that on the 8th of May, Prince Buthelezi held a media briefing where he stated that the issue of the succession to the throne had been finalised, and that anyone who wished to contest the appointment of Prince Zulu as a successor to the throne must go to court. My Lord, this allegation, it was published in the newspaper, but it was blithely denied by Prince Buthelezi, but he doesn't provide any details as to what he in fact said on the day. On the 12th of May, the princesses, the applicants in this application, received a text message informing them that they were required to attend a cleansing ritual following the interment of the late Queen on the 14th of May. Now, I'm going to just pause there, my Lord. The purpose of the meeting on the 14th of May is stated by the princesses and is on oath, and it doesn't appear to be denied, that they were notified that there was a cleansing ceremony to take place on the 14th of May. No suggestion was made that there was going to be a meeting to determine or identify the successor to the throne. There wasn't even, oh, by the way, at that meeting we might think about or contemplate who should be the successor. So one would imagine, being the princesses who were the direct descendants of the first queen of the later Silo, that they would have had some interest in the determination as to who the successor was. In fact, there is no dispute that they form part of the royal family as contemplated in the Khoisan Act and the KZN Act. They are part of the core royal family. You know, they are the daughters of the later Silo from the first wife. They were notified that there was a cleansing ceremony. But Lord, the meeting on the 14th of May, it is alleged that at that meeting, Prince Mrs. Zulu was identified by the family as their nominee as the king. Lord, the nomination of Mrs. Zulu appears to have emanated as a result of the letter and the will of the late Queen. The only significant reason the late Queen might have had any basis for nominating a successor to the throne is in the event of her being nominated as the Queen or the Silo by the late King.
So let me get this thing clear.
My Lord, might I?
Are the applicants challenging the identification of...
We're certainly challenging the identification meeting. The identification meeting is challenged, it is dealt with. But I'm taking your Lordship to the...
challenge in which sense? In terms of the will or in terms of the tradition?
But my Lord, it's on the basis that that meeting, that's the... Bearing in mind, my Lord, what the applicants essentially challenge is they challenge the identification as set out in the will. In the will. Because, and I will take your Lordships through the argument, my Lord, but Ms. Buthelezi, and we must concede, my Lord, set out in some detail as to how significant the identification of a successor by the late Silo was to the succession race. And they set out in infinite detail as to why in the past and in customary law, the identification of a successor is of fundamental importance. In fact, your Lordship will find that Prince Simakadi at that stage had declined to challenge the position on the throne because he had been advised that he should not put himself up against the wishes of the late Silo. Now, my Lord, if I might, before I get to that, if I might just finish the chronology. On the 18th of May, the princesses delivered their supplementary affidavit. My Lords, they were unaware at that stage that a nomination process had taken place, or purportedly taken place, at the meeting on the 14th of May. The meeting on the 14th of May was not a meeting which was scheduled for the purpose of identification of the king. It was simply a cleansing ceremony. That is common cause that's what they were notified of. On the 20th of May, an initial answering affidavit was delivered on behalf of the 2nd to 6th advance respondents, and a consolidated answering affidavit was delivered on the 30th of June. Now, my Lord, let us deal with the defences to the application which are raised by the applicant. The first defence they raise, my Lord, is they say that the respondents allege that the later Silo's signature on the will is authentic. So, my Lord, that's the first argument they raised. That is at paragraph 27.1, page 371. They say his signature is authentic, notwithstanding the fact that they have no personal knowledge of whether it is or isn't. They simply blithely submit that it is. It is notable, my lord, that the very people that one would have expected them to provide as witnesses to prove the authentication of the signature are the witnesses who purportedly signed it. They know the identity of the witnesses. If they simply, in order to prove the authenticity of the will, one would have expected the respondents to provide a confirmatory affidavit from the witnesses to say, the king signed this will in my presence, and I'm aware that that is his signature. They don't do that. My learned friend Mr. Topping yesterday indicated that according to their information they've now obtained, I haven't seen the information, but they suggest that in fact at least one of the signatories had not appended his signature to the will at the time of signing the will. Now, my lord, therefore it's surprising that the respondents so blithely contend that the will and the signature to the will is authentic, whereas they don't provide any evidence to that effect. The expert report of Fusoka, this is an expert report that was obtained by the princesses, sets out in some detail why he concludes that the signatures on the impugned will were not signed by the Late King. And we set out some of the statements made, my lord, and I do wish to read them into the record because they are significant. He sets out the process of examination, and then he concludes, my lord, it's paragraph 42.1 of my heads of argument. He concludes that generally it can be said that the only consistency amongst the 8 signatures in set 1, that is the signatures which are appended to the impugned will. So the only consistency is their shocking inconsistency. He says, in all, we must take into consideration that set 1 as a will that was supposed to be signed in one go with a passage of a second between each signature, so therefore no major changes should have been expected to be found. Instead, we find all bunch of 8 signatures which are differing by all available and possible elements: style, size, fluency, speed, continuation, interruptions, pressure, etc. He says, in addition, he says, my lord, that in general all the lines and movements on the signatures are shaky, wobble and vibrate. In respect of one of the signatures, he suggests, my lord, that the signature was made as if a drunk person or an 8-year-old child was asked to imitate the signer's signature. The conclusion of the report, my lord, reads, based on, in accordance with accepted and proven document examination standards and in the view of certain individual characteristics, as has been described and elaborated on above letter, with special attention to those points reflecting uncharacteristic noted next to them, I can conclude that set 1 and set 2 have not been written, signed by the same hand, being that of the late His Majesty King Zwelithini Goodwill Zwelithini. My lord, that is the conclusion, and that is those are the details set out in the expert report. There was a challenge that he had not signed a confirmatory. Your lordship will note that he has in fact put up a confirmatory affidavit. My lord, in response to that affidavit, the respondents provided a report by Cecil Greenfield. Greenfield says he used a technique, and he utilized another will, which he said he used an acknowledged will for this purpose. My lord, there is no acknowledged will. But in any event, my lord, his findings are set out in paragraph 45 in my head. He states the following: notwithstanding the similarities, there are obvious dissimilarities. So he notes that there are obvious dissimilarities. He says this is not unusual, as variation is bound to occur in everybody's signature. He says at paragraph 7, there are obvious dissimilarities. However, in my view, these can be attributed to natural variation, the time gap and accidentals. Now, with due respect, my lord, one has reference to the 2 reports. One is a detailed analysis of the signatures. The other one is one which picks up dissimilarities in the signature and concludes that they could be attributed to variation in time gap and accidentals. As Mr. Fasoka indicated, my lord, the signatures would have been signed at the same time. It was one document. They would have signed within a second of each other. There was no time gap in the signatures, and there should have not been these fundamental and obvious dissimilarities in the signatures. My lord, he then concludes that the signatures were probably, he says, despite the obvious dissimilarities, the signatures noted by Greenfield, despite the dissimilarities, he concludes they were probably written by the later CC. This conclusion is unsupported. It's simply, he said they were probably written by the later CC. Now, with due respect, my lord, I'm not asking your lordship to make a determination at this juncture as to whether the will is a forgery or not. We're alive to the fact that that issue is something which must be referred to trial, and it is sought that the matter will be dealt with at a trial in due course. The question that your lordship now needs to determine today is what are the consequences of the will if it is in fact a forgery. Now, the consequences of the will, my lord, is that in the will, the later sealer purported to nominate the late Queen Domini Zulu as the heir to the throne. The answer to that by the respondents is they say, and it's found at page 20 of my heads, my lord, we deal with it. I'll deal with it in the allegations, don't we? The expression of the late sealer and the late Queen. Yes, madam.
According to the will, the person was nominated as the late Queen.
Yes.
Not Prince Mrs.
No.
Does not feature anywhere in this will.
No.
So now, how his identification is challenged?
How?
His identification as the successor is challenged.
Yes. Because he was nominated by somebody who was nominated in this will. He was nominated in the will of the late Queen.
Yeah.
So the late, and obviously the reason the Zulu Royal Family would have accepted the nomination is because they understood, or would have understood, that the late sealer had nominated his queen. The queen who ought to have been the descendant to the throne in accordance with the will, then in turn nominated her son.
But now, the Queen's will is not an issue here. The Queen's will,
We're not challenging the Queen's will.
was nominated.
Yes. But we cannot escape the process that was followed. The Queen only became a person who could nominate somebody under her will to be elected to the throne. And she nominates her son as the heir to the throne.
Yeah.
The only reason she can do that is because she herself had been nominated as the heir to the throne by the late
And
king.
that was not the only nomination. There was also a nomination by the Royal Family.
There was a nomination apparently by Prince Buthelezi, so he says, but I will take you, your lordship, through the minutes of that meeting.
Okay, but in any event, according to the respondent, there was a nomination at the meeting of the Royal Family. Apart from the will.
Yes, my lord.
So whether the will is there or not there, what do we say? What do we
Yes.
do about with this
Well, my lord,
nomination?
our argument, and I will develop the argument, but our argument is you cannot discount the late King's wishes, because the late King's wishes as to who should be nominated is something which is fundamental to the identification of a successor to the throne. And the respondents make it very clear, and they set out, and I'm going to take your lordship through it. I'm going to go step by step as to why the King's identification of his successor is crucial to the question of the identification of the successor to the throne. And who did the King nominate? We know who the late Queen nominated, but what significance is that the late Queen nominated her son? The late King did not nominate his son. And why? There's a question that ultimately will be determined at a later stage. But according to the respondents, they set out the whole process, and they deal with the process and the royal family and who should inherit and who should be appointed as the successor to the throne. And they show and they demonstrate why the king would have nominated the firstborn of a royal family, or they attempt to establish that. And then they say the will confirms the customary position. And the will does exactly the opposite. The will nominates his queen to be the heir to the throne.
But are you saying that the nomination of Prince Msuzulu was solely based on the will?
No, I'm saying the nomination of Prince Msuzulu was impacted by the fact that his mother had nominated him, and she had derived her power to nominate him as a result of the will of the late Isilo, the impugned will. So the impugned will had nominated Prince.
What do you say about the Zulu tradition? That a wife whose lobola has been paid by the nation is the wife who should bear the heir to the throne.
Yes, my lord. I know your lordship has written an article in regard to that. It's raised in the heads of argument, and I'm going to have to.
I'm talking about what they are saying. Yeah.
But my lord, might I just make?
Now, what I want to bring to you.
Yes.
That even apart from that will,
Yes.
will is not binding to the royal family.
Yes.
Because if the will was not in accordance with the custom, they would not follow that will in any event.
My understanding is the custom. There's a number of customs which are raised. Your lordship has raised one of the customs which your lordship suggests in the article and in this some other writings on that, my lord. Whether that is correct or not, what we know as a fact, my lord, is that I'll take away A, but certainly what we know as a fact is that the king did not follow that custom in this will. And what we also know as a fact, my lord, is that the identification of the heir to the throne by the royal by the seated king is of crucial importance. In fact, my lord, the King Prince Buthelezi sets out in chapter and verse the history of the Zulu nation, and as to how each of the kings was nominated by virtue of his predecessor. And he shows us. I want to take your lordship to the extracts. Now, let us assume, my lord, that the king had nominated his firstborn son of the second wife as the heir to the throne, and that's who he identified as the person by putting it in his will, what would the position be, my Lord? We know what the position has been in the past, that the royal family in most instances will stand back and accept the nomination of the king, notwithstanding the process where the suggestion that there's a royal household.
I was suggesting or submitting that even if it is not in accordance with the Zulu custom and tradition, they will accept, because there is a tradition or a custom which says there are two things, which is the prime requirement for identification of the successor. A successor born of the mother whose lobola was paid by the nation.
Who's the?
That is a requirement. The first one.
Yes.
And this one is born of a royalty of a Swati. There's the other thing. That lady precedes all other ladies in the marriage and becomes the great wife. That is the customary law and tradition. So if the king were to appoint somebody against the tradition and the custom of the Zulus, then the royal family will not be bound by that.
Well, my lord, that's not what Prince Buthelezi says in his affidavit. He deals with it, but he sets out, and I will show your lordship, why he indicates that the nomination made by the king is the significant nomination. And the royal family will seldom not, and the tradition and customs of the royal family is that the identity of the person who the king nominates.
Does he not say that is not decisive, which is common cause also with the princesses?
Well, my lord, it might not be decisive, but it's certainly highly influential. And if the determination in this, that this will is in fact a forgery, is made by the court, we're going to be in a position where the nomination of the late queen was invalid, and then the question is, who did the king in fact nominate as the Asila? And we say, my lord, that identification process is something which needs to be held back pending the determination of this matter. Now, my lord, we're not asking for a great delay in this matter. In fact, my lord, we would ask and implore the court to refer this matter to trial and put to put the question of the will to trial, send the question of the will to trial, and compel the parties to comply with expedited time periods, and it can be dealt with. Once the level fields have been, so the playing fields have been leveled, at that juncture, the decision by the royal family can be made as to who the identity of the incumbent king should be.
Do the princesses have a claim to the throne? Are they contenders?
They don't contend that, my lord.
Why they should?
My lord?
Why the identification of a successor should be interdicted?
Because they have an interest, being members of the royal family and Zulu and members of the Zulu nation. They have an interest in who the future king should be, and that the process is followed in accordance with the Zulu custom and tradition. They have a real interest in that, my lord. And I'm certain other members of the royal family and members of the Zulu nation would believe that it's necessary for this inquiry to be finalized before a determination is made as to who should be the future king. My lord, if I might then take your lordship to paragraph 50 of my heads of argument, my lord. And I'm dealing with my lord, I'm dealing expressly with the defences raised by the respondents. And the defence that they raise is they say the following: the expression of the late Isilo and the late Queen's wishes in the form of a will or testamentary instrument or letter confirmed the known position at customary law, i.e. that the late Queen's eldest son would succeed the late Isilo. I see my learned friends nodding his head and saying that is what is said. But that's precisely what the will does not say. The will does not nominate the late king's first son born of the royal household as the heir to the throne. It nominates the Queen as the heir to the throne. So how does this will that they rely on confirm the customary and traditional law position that they suggest? The late Queen's, my lord, the late Queen did not ascend to the throne, and accordingly her nomination of her son, the son was not nominated by the late King. The nomination of his son, alternatively the nomination of one of her other sons, was not a nomination which accorded with customary law as suggested by the respondents. In the letter that was written by the late Queen to the family, she acknowledged that the late Isilo's bestowment upon her of the honour to succeed him and to assume the role of Zulu monarch. So she accepted it. She acknowledged and accepted it. She says that there doesn't appear to be any precedent, my lord, where an Isilo has appointed his wife to be the Queen of the Zulu nation.
To be the successor.
The successor. I know of no precedent.
Can appointed her son.
My lord?
I said he and his wife in turn appointed her son as a successor.
The wife.
So then you say that impacts negatively on the identification of the Prince Mrs. Zulu.
My lord, but the Queen was never appointed as the Queen of the Zulu nation. She never.
But in any event, was he appointing him as a successor, sorry, as a queen, or was she appointing him at the time in her capacity as a regent?
Yes.
What was the position?
Page 120 of the pages, my lord, is the will. Paragraph 15.
Yes. Paragraph 15.
Yes. I'm going to read and I'm going to emphasize the words that are written in bold. As regards my successor to the throne, I hereby nominate and appoint SM Zulu identity number 5102. So he nominated her as his successor to the throne.
I understand that.
And what the respondents say in their answering affidavit, they say this will confirms the customary and traditional law position of the Zulu nation. That they specifically say that. This was just a
Do they explain in which sense it confirms it?
They say, my lord, in the sense they say, the expression of the late Isilo and the late Queen's wishes in the form of a will or testamentary instrument or letter confirmed the known position at customary law, i.e. that the late Queen's eldest son would succeed the late Isilo. Now that's not what the will says. So insofar as they suggest that it confirms the customary law position.
Are they suggesting that that's what the will says? Or are they stating the Zulu custom and tradition, or what is the position?
That's their defence, my lord. That's their defence, which is expanded on in their answering affidavit. My lord, they say, I've read out the defence, they say that it confirmed the customary law position. Now the question is, the king in his will, in the impugned will, did not nominate the son of the alleged royal marriage.
Maybe, well, no, that's saying that it confirms the customer position in the sense that, in fact, in terms of the custom, Prince Masisulu is the one who should be a successor.
Yes.
Are they not saying that in that fashion?
My Lord, they're saying, well, that's not what the will says.
Yes, the will does not say that. But
So it doesn't confirm that position.
you mean the will of the king?
Yes.
The will of the king is appointing the late queen.
Yes.
It doesn't say anything about Prince Masisulu.
Yes.
Prince Masisulu only comes into the picture in the will of the late queen.
Yes. Yes. And the late queen, in the letter and the will of the late queen, there's no doubt, well, I say there's no doubt on these papers, that the late queen appears to have nominated Prince Masisulu. But as we stand here now, the late king did not do so.
No, it didn't.
He did not do so. So now the question is, if the will is set aside, is there a nomination that the king did make during his lifetime? And I will take your lordship to the tradition and custom as described in the answering affidavit in this particular matter. My Lord, paragraph 53, my Lord, the late Queen in her letter indicated that if Prince Masisulu did not accept her nomination of him, she would accept the late Isilo's wishes and she would succeed him. That, your lordship, will find at page 332 of the papers.
So, what page?
Page 332, my Lord. Says paragraph 7, I am hopeful that Umtantwana Zulu will accept this honour and duty with buoyancy. In the event that he does not accede to my wishes or is not appointed, and only in those circumstances shall I oblige with the King's wishes that I should succeed His Majesty.
So in other words, she was abdicating in favour of Prince Masisulu.
My Lord?
She was abdicating in favour
Yes,
of...
she was. Well, she wasn't abdicating, my Lord, because she was never appointed as Queen.
But in terms of the will, she has been appointed as a successor.
But she was never coronated as the successor to the throne. My Lord, at paragraphs 45 to 47, in fact, my Lord, if one starts at paragraph 40 of the answering affidavit, the following is stated. Although important, the identification or nomination or appointment of Prince Masisulu Zulu as the King of the Zulu nation is not solely dependent upon the validity of the late King's will. So what is of significance there, my Lord, is they say it's not solely dependent on the validity of the King's will. Meaning it is to a degree or to an extent dependent upon the validity of the King's will. Paragraphs 45 to 47, my Lord.
But before you go to that,
My Lord.
when you look at the Act does not make any provision for the will. It makes provision for the royal family taking a decision to identify somebody and advance reason for identifying that person, and which information should be forwarded to the Premier or the President, whoever.
Yes.
So now, if we say Prince Masisulu was identified solely on the strength of the will. Could that be correct? Because no will was forwarded to the Premier or to the President.
No, my lord. The identification takes place at the level of the royal family, as I understand it. They identify the person who they then refer to the Premier for recognition.
They identify the person at their own meeting.
Yes, yes. And the person they identify is identified in accordance with Zulu customary law.
Yes.
So that is the understanding, my lord. Then, my lord, at page 300, my lord, paragraph 45 onwards, they set out the history of the Zulu nation and the traditions which are applicable, my lord. And they say the process of appointing a successor to the throne by expression of such wishes in a document, be it a will or a letter, is not without precedent in the Zulu nation. It is embedded in and part and parcel of Zulu customs. The incident that comes to mind, and then he sets out the incident relating to King Solomon that your lordship will be aware of. And it's a question, and it refers to the praise song of Prince David, who was the king for a day. Paragraph 48. Accordingly, there is no dispute about the ascension of Prince Mzulu. Zulu is the king of the Zulu nation. Prince Zulu is, after all, the rightful heir to the throne in terms of Zulu customary law, customs, and traditions. They then expand on the theme at paragraph 39 to 49. And this is a very significant paragraph, is 49. It's the answering affidavit.
Of which volume? Which page?
It's page 301, my lord.
301.
My lord, I've started at paragraph 45 on page 300, where they deal with the question of the identification, and then at page 301, it says, I am not aware of anyone in the Zulu nation or the royal family who has ever disputed the correctness of the custom. This is the custom of the king identifying his heir. Who has ever disputed the correctness of the custom by which the name of Prince Msizulu was raised and endorsed in the Zulu royal family. Indeed, the applicants have made no such claim. Accordingly, there is no dispute that the successor to the Zulu nation, and then they set out why they suggest that Prince Msizulu is. Then, my lord, at paragraph 47 on page 379, my lord, it's in the supplementary affidavit, answering affidavit. Page 379. This is of extreme importance for me. It says, thus, the matter was thus regulated by the prevailing customs of the Zulu nation, namely, that the king would nominate and appoint his successor to the throne, and the royal family would not invariably speak against the wishes of the fallen king. That is the invariable situation. The royal family would, if he nominated somebody...
379, what paragraph?
It's paragraph 47, page 379. In volume 5. Paragraph 49 goes on. In fact, 48 says, I should add, the reasons which will become apparent momentarily, that the appointment of kings, and I've referred to the above, was in accordance with customary law of primogeniture, which required that the first son born of the first wife of the fallen king, with the exception of a situation like the present. So he suggests. And one of the wives enjoyed precedence.
Is this referring to the present time or in the past?
My Lord?
I mean, this paragraph is referring to the present time or in the
It's referring
past?
to the custom, my Lord. He then says at 49, accordingly, as a matter of customary law and custom, the express wishes of a king during the lifetime as to who should succeed him, for as long as it is consistent with customary law, has always prevailed. Those wishes are thus no irrelevancies. So, on the contrary, they are important considerations, historically taken into account in determining the successor to the throne. And those wishes evince the king's own understanding of customary law applicable to succession, as the king is the traditional, customary and cultural leader of the Zulu nation's customs and traditions. His wishes are a strong indication of the customary law position. So, my Lord, the king's wishes in this instance are a strong indication of the customary position. The king's wishes were that his wife be the successor to the throne, in accordance with the law. If the king nominated someone else, then in accordance with the custom and tradition, the royal family would be unlikely in those circumstances not to, or to speak out against the king's wishes. And my Lord, the point being, the respondents themselves emphasize how important the king's wishes are. My Lord, if I'm going to go quickly because I note that I'm running out of my allocated time. My Lord, I'm going to then go to the provisions of the Khoisan and KZN Act, and your Lordship will be cognizant of the fact that both acts are similar in nature, that they require that the identification process be undertaken by the royal family in accordance with the traditions and customs of the customary law and custom of the Zulu royal family, of the Zulus. My Lord, it's suggested by the respondents that the identification took place on the 14th of May. Your Lordship will recall that I've already indicated that this application had already been launched at that stage. The princesses were not invited to a meeting for the purpose of nominating a king. They were invited to a cleansing ceremony. And, my Lord, at that meeting, it's indicated in the replying that the respondents suggest in their answering affidavit that was the meeting where the identity of the future king was made. Now, your Lordship does not have to make a decision as to whether there was a correct determination, because that is something which ultimately may or may not be the position. But your Lordship does need to make a determination as to whether that meeting constituted a meeting for the purposes of identification of and nomination of a successor. My Lord, there was no invitation at the meeting. At the meeting, my Lord, if I might take your Lordship to the minutes of the meeting. Page 348, my Lord. So my Lord, my name Genius referred me to the Zulu version of the meeting.
That's the meeting of the 14th of May,
Yes, my Lord.
which, according to the respondent, is the meeting in which Prince Masuku was identified as a successor.
Yes. Well, my Lord, it's a meeting where they suggest that he was identified at that meeting, my Lord, by the royal family.
Yeah.
My Lord, it's at page 461, volume 6, my Lord. My Lord, and the opening words of that meeting are quite significant. And bearing in mind, this is a cleansing ceremony, my Lord. There were persons there who were not members of the royal family. And I'm going to show your Lordship why the Constitutional Court determined in the imperial matter that the presence of other persons who are not members of the core royal family renders a decision of that meeting not a proper meeting for identification purposes. My Lord, but paragraph 4 is significant.
How do you identify them as not being the members of the core royal family?
Well, my Lord, the allegation is made in the replying affidavit where they specifically said that there were members of the royal family, there were members of the meeting who were not members of the royal family. And if one goes through the list, and because the Prince Buthelezi purportedly set out the houses as to which they belong, if you look at some of them, they're clearly not members of the royal houses as suggested by Prince Buthelezi in his answering affidavit. So one merely needs to look at them, and one can note that they, in fact, the royal houses are not the royal houses of the Zulu family.
Well, this may be confusing because, according to the Zulu tradition, a child born of a princess is also a prince or a princess, and a member of the family, of the royal family. Now, bearing a different surname may not conclusively lead to that person is not a member of the core family.
Yes. Well, the
that's the problem I may have.
The question is, my Lord, this is then your Lordship is not in a position to determine that that was in fact a meeting of the royal family, the core royal family, as required by the provisions of the Act. Your Lordship cannot find that the succession, that there was in fact a proper identification on that day. That your Lordship cannot do. What your Lordship, if your Lordship has reference to the meeting, where your Lordship will see the opening statement at the purpose of the meeting. It says, Prince Mangosuthu Buthelezi welcomed all members of the royal family, reserving all necessary protocols, and expressed appreciation for the presence of all the members of the royal family from their respective palace and for assuring unity. Prince Buthelezi introduced the new incoming king of the entire royal family as being Prince AmaZulu Royal Zwelithini Kabeka Zulu. And that was the introduction to the meeting. The family was introduced to the person who Prince Buthelezi said was their new king. So that's...
In other words, she was merely appointed by Prince Buthelezi.
My Lord?
In other words, she was merely appointed by Prince Buthelezi.
Well, it seems to be ushered through to a certain extent, my Lord. But it's certainly, this is not a nomination by the royal family at that juncture.
Well, he may propose the name of the person, and others also supported him.
My Lord, there's the support seems to be more welcoming him as the person.
So in other words, he had already been appointed somewhere.
Well, it seems to be ushered in the sense that it's a foregone conclusion. There was no debate or consideration or as to whether he was the person who was identifiable in terms of the act. We know it was a cleansing ceremony, my lord. We know that it wasn't a meeting, and this is a fact, my lord. One has to accept this. It wasn't a meeting that was scheduled for that purpose, or certainly the persons who were core members of the royal family were not notified that it was for that purpose. And that, my lord, for something as important as the appointment and identification of the future Zulu king, that is of something of huge significance, and one would have expected the persons who were going to participate in that process to have been properly notified and advised as what was going to happen.
How this is going to help the African princesses? Because if they are not contenders and got no wish to be appointed, whether this was a meeting for identification or not, how that is going to help their case?
Yes, but when your lordship speaks of the princesses, your lordship is obviously also taking cognizance of the fact that they're not standing on their own. There are a number of applicants in this, many members of the royal family who are participants in this application, who have signed confirmatory affidavits in support of the princess's application. So, and how does it impact them as to who their king is, and that the process is properly followed? My lord, our submission is that they're entitled to question the process, and they're entitled to have the process stayed. That's what they've approached the court, my lord. Whatever the process that has taken place at this stage, the princesses seek simply to stay the coronation pending the determination of the will dispute. Yeah. Your lordship is not required to make a determination, because it's not on the papers, and there's other people.
Why should we waste time on it?
On?
Because on this, because if that is not going to help them, that's why I'm asking this question. Because if you are dealing with things which are non-issues and not going to help their case in any way, why do we deal with it?
My lord, I'm simply indicating to your lordship that the princesses have brought an application to stay the coronation of Prince Mrs. pending the determination of the will application.
Because they believe that this was not a meeting convened for that purpose.
No, they believe that any nomination arising out of the will, or as a result which was affected by the will, should be.
So there are cases that there was no any other nomination than what was done in the will. Is that their case?
My lord, yes, my lord, that was their case when they brought it, my lord. Bearing in mind, when they brought the application, this meeting hadn't taken place. Because your lordship will also take cognizance of two other facts, my lord. One is the fact that there's a countervailing matter, which is where another portion of the royal family has nominated Prince Simakadi. That appears in the supplementary affidavit. And the other issue, my lord,
that is quite surprising if you say that this has not taken place, but how this thing is included in their papers.
My lord?
If it took place, they say they lost their claim on the 7th of May.
29th of April.
The 29th of May.
I think it was April.
29th of May of April.
Lord. It was set down for the 7th.
And this event took place on the 14th of May.
After the...
So how that is included in their papers?
It's not included. It's not, my lord.
It's not included.
No, my lord. It's in the respondent's papers.
Oh.
They raise it. So this is something. The respondent hasn't come to court and said, we want you to confirm the succession that we properly. What they say is, my lord, is that you shouldn't interdict the coronation because there's been a process that's been followed after the launching of the application. You will also take cognizance of the fact that they say that there was a meeting on the 29th of September where the nomination took place. But, my Lord, those issues, whether those meetings were properly convened, whether there was a proper process, all of that can be dealt with if necessary in due course. What the princesses at this stage seek is merely an order staying the process. Pending.
Why is she staying the process? Because she's not a contender, she's not in any way involved except to say she's a member of the family. Why should
because
why the process should be stayed for that person who is not a contender?
But my Lord, your Lordship is asking me whether she has the locus standi to bring this application. My Lord,
she's not.
She most certainly, I would submit, does, because she is a member of the royal family. She has a real interest in who the future king is, and that the process. She has a real interest that the process which is ultimately followed is the correct process.
Are you suggesting that any member of the royal family can come up and stay the coronation simply because he's a member of the royal family?
They can stay
because there must be a person who's a contender and has got a better right.
No, my Lord. No, my Lord. It's not. This is not a fight over succession. This is a question as to the staying of a process until the determination of the will has been made, and then the question as to who the king identified as the successor can ultimately be determined.
But my problem, Mr. Redmond, let's say I'm a member of my Dwanda family.
Yes.
Dwanda family is very large.
Yes.
So if I'm not the successor and I'm not the contender, can I come in and say, no, let me stop this because I don't want to see it going on. Because I don't understand why we are busy with this. Because I would understand it if these princesses are contenders. Or they put somebody forward to say this is the person who's got the better right than Prince Msuzulu. So if Prince Msuzulu is appointed, then it will be appointed wrongly or not in accordance with the Zulu custom.
Yes.
But now, why are we dealing with this?
But my Lord, if your Lordship accepts that any member of the royal family or of the Zulu nation would be entitled to review the decision if it's not in accordance with Zulu customary law.
Well, if it's not in accordance with customary law,
yes,
you put it forward. But then and also it doesn't end there. Must state who the person who's got a better right or better entitlement.
Well, my Lord, the
but not just shooting in the dark and then we don't know why are we busy with this thing. Because if Lord, they say I'm a contender or so and so is a contender has got a better right on these grounds.
My Lord,
then that is understood. And
Lord,
whether that person
said,
is mandated then is another story.
My Lord, if they said there is another contender.
It's not.
But if they said if there's another contender, your Lordship would say, well, then they might have
another contender. Who's another contender? What rights does that contender have as compared to the present person who has been identified as a successor?
My Lord, we're simply seeking a stay of the process pending the finalisation of the dispute on the will.
Just simply stay the process for pleasure. You must.
It's not for pleasure.
You must satisfy in this court that the ground, the reasonable ground for so doing, that you have got substantial interest, which gives you the power to do that. You can't just do it because you don't like somebody who has been identified as a successor.
No, my Lord, one has the locus standi. We have an interest. We have an interest in that the process be properly followed.
Yeah, they have interest, but they cannot go to an extent of stopping the process.
But they have their
what
argument.
Right do they have to stop?
My Lord, their argument is that they seek to stay a process that they contend is irregular.
Why?
They say it's irregular because of the fact that they have this forged will, which informs that and distorts what they say is the true identification which might be made by the king.
That will, in the first place, Mr. Radman, does not say a thing about the identified person as a successor. That's the first thing.
It does nominate the Queen.
No. It doesn't say a thing about this person.
Oh, not about this person, no.
Yeah, it doesn't say a thing. And secondly, the respondents do not only rely on the will. In fact, they don't rely on the will. They rely on their identification, which coincides with what the late Queen did. So I really don't understand why they can be allowed just to interfere in the process without clearly indicating how this thing is going to adversely affect them. They must be somehow adversely affected, is not so?
My Lord, I've made out the case.
But it's not, that's why I'm having a problem now. That you spend
Your Lordship feels that if they identify
something which is not going to adversely affect these people.
But my Lord, Your Lordship is concerned that if a person does not stick up their hand and say, well, I am the person who should be nominated,
yes,
therefore they are not entitled to interfere with the process, even if the process might be flawed. It's only if there's a challenge to somebody who is a challenger to the throne that puts that. Our submission is, my Lord, that the playing, we simply seek an order that the playing fields be levelled, my Lord. That the question as to the succession to the throne be dealt with in circumstances where the determination of the king can properly be assessed without reference to a will that the princess is alleged forged. And we say that in the absence of at this stage a valid nomination, or in the absence of an identification as to who the king selected as his predecessor, it's an unfair situation and a flawed process.
Okay.
My Lord,
I think we have exhausted your time.
my Lord, yes, I know. My Lord, we do indicate in our heads of argument that it's made very clear, but that other candidates will not stick up their hand in circumstances where they believe that the late Silo has nominated a certain person. And that is referred to by Prince Buthelezi, and it emerges very clearly from the letter by Prince Makadi. He says, let me make it clear that my aunt, the Princess from Ndlovu, together with Prince Khwaphezezi, once warned us children of the king that if the king or queen ever nominated one of our names, the nominated individual must accept the nomination. So too, if I had been nominated, would accept the nomination. They had also warned us that if one of us has been nominated, the rest of us should accept and support the nominated individual.
And that person is denouncing being the contender.
My Lord?
And that person is denouncing also being the contender in that letter you are reading.
Yes, but we know that that's subsequently been overtaken by events. But he says, as a respectful child, and one that I think is humble, I'm sure that I will not...
Is it the right person to be appointed? Because he doesn't say anything. Because he says, okay, the person who has been appointed has been wrongly appointed because of ABC. I'm the person who's the better entitled to be appointed in terms of the Zulu custom and tradition. But we cannot just say that the person who's diving, he doesn't know whether he's a contender or not.
Well, my Lord, we know that he supports this application.
Yes?
He supports this application, my
You
Lord.
may support the application, but it must come forward because there's no party who's put forward as a person who's a contender
Because they
to
believe,
Prince Mrs. Zulu.
because they understand, my Lord, that the King and Queen had nominated Mrs.
So
Zulu.
then they abide by that.
That's what they say, my Lord.
Why now should they worry?
Because, my Lord, it now emerges that the late Queen, so the late King, may not have nominated.
Why they should not abide by the wishes of the late king?
But what were the wishes, my Lord? What were the wishes of the late
If
King?
they are so obedient.
My Lord, Your Lordship, the question really arises: what were the wishes of the late King?
Yes, the late king, the late queen. You see, they abide by the wishes of the king. The king then appointed the late king, the late queen, who in turn appointed Prince Misuzu.
Yes.
So then, what he portrays there, he portrays himself as an obedient child
Yes.
who takes from the elders.
Yes.
So why does he not accept what the late queen has done?
Because, my Lord, the very start of what Your Lordship sketched out to me, the late King, the will is challenged, my Lord. I've indicated to Your Lordship the challenges to the will.
Yeah, okay, it may challenge the
So,
will.
my Lord, Your Lordship says, well, the late King he did, according to, we don't know that, my Lord. We don't know whether the King did in fact make that determination. If Your Lordship finds that will is in fact valid, then Your Lordship can say, yes, that was the King's wishes.
Okay, thank you, Mr.
But, my Lord,
Redman.
might I just wrap up, my Lord? My Lord, the relief sought in the application, as indicated, Your Lordship is not required to determine the succession. Your Lordship is merely required to determine whether the applicants are entitled to intervention relief sought. And my Lord, paragraph in the light of the dispute relating to the will, there can be no dispute that they're entitled to interdict the execution of the will at this junction. We submit that ancillary to that is the interdict that they seek, pending the coronation until the matter has been determined.
But in any event, is there any coronation underway?
My Lord, if Your Lordship has reference to the relief we seek, we seek to pend any further processes. Effectively, the applicant seeks to pend any further processes until the will issue is determined.
Why do they come to the last stage? Because that is the thing that's multi-layered. The first is identification, the recognition. If there's any complaint, that complaint should be investigated and post-investigation. Then the coronation is the fifth stage.
Yes, my Lord.
Why should they jump there?
Well, my Lord, that's exactly why one would stop. One would interdict the horse from bolting before the horse is bolted. One wouldn't want to do this at a later stage.
But now you ask me to stop something which does not exist.
Well, we're asking you to stop something which is the process which is proceeding. There is a process that is proceeding. We're saying stop the process for the moment until this forged will can be determined, and then the process can continue.
But there's no process, Mr. Redman. There's no process underway to coronate Prince Misuzu. There's no process at all, according to these papers.
But my Lord,
And you also cannot give me any proof of that process.
But my Lord, the respondents give you detailed proof of what the process
About
is.
the coronation.
Not about the coronation, but about the.
No,
my Lord, I
but
refer to
let's
coronation.
open the coronation. Where
I've
is
showed
the
you, Lordship, that
coronation?
in the relief sought, it's not merely the coronation. It's the process which leads up to the coronation that we seek to interdict. I use coronation in the wide sense of the word, my Lord. I'm not saying
But
that.
in these prayers, we are not referring to coronation.
No, my Lord. I just, when in argument, I refer to it merely as a reference to the process that takes place. Why don't I just read your Lordship? Your Lordship has seen the prayers. Is it good? It's the, yes, sorry, my Lord. My learned friend correctly points out it is there. Now it's just going to be interdict from announcing the date of the coronation of the King. Until this will issue is determined.
The coronation which is not there.
It's my Lord.
Because you can't tell me that any coronation underway should be stayed, because there's no coronation.
Yes, well, we're asking.
If somebody is dreaming of a coronation, then we have to stop that.
So is your Lordship suggesting that only once the date of coronation? We're asking that
there must be proof of that. The word is in papers by the government, whoever, who says now they are preparation for the coronation. Where is that?
There is no allegation on.
Because it's just a say-so of the African princesses.
My Lord, we're asking simply to stay any process relating to the recognition or coronation of Prince Misuzulu until the will issue has been determined. And that's all we're asking for, my Lord. It's simply an interdict to stop the process. And my Lord, the will issue, as I indicated, your Lordship can expedite the hearing of that matter. Your Lordship has it in his power to hold the parties to terms as to when that matter should be heard. And that can be resolved, and that may or may not have a fundamental impact on the ultimate determination.
Okay.
Those are my submissions.
Thank you. Mr. Matansela, you have anything to say?
As a court, please, my Lord,
And you must see the nail on the head.
I just hope to do so, my Lord, if I don't have interruptions from the court, which might make me digress.
I will be interrupted if it is required.
Yes, my Lord. May I please summarize our position? Our heads of arguments are quite comprehensive in this particular regard. The convenient starting point, my Lord, is to recognize what this interdict is all about. The interdict is about interdicting the recognition of the King Misuzulu or his coronation, pending the proceedings which the applicant intends to bring or has already brought, which must be referred for trial, relating to the impeachment of the will of the late King Zwelithini. Now, my Lord, the will of the late King has got nothing to do with the identification or the appointment of King Misuzulu. Nothing whatsoever. Now, viewed from that perspective, insofar as the interdict has as its object the recognition of King Misuzulu by the Premier or the President, or his coronation by the Premier, the interdict is effectively a final interdict. Because it is, if it were to be granted, it will be granted pending nothing relating to the appointment or recognition of Misuzulu. So we are not here concerned with an interim interdict. We're actually concerned with a final interdict in relation to the recognition and the coronation of Prince Misuzulu. Because those, if the court was to grant that interdict, nothing that will that will come out of the impeachment proceedings will have any bearing whatsoever to the recognition of King Msizu. So this case is clearly about succession. If we are right about our contentions, then it must be the end of the matter, because it is a final decision on this issue, at least on these papers. And because it is a request effectively for a final interdict, the matter must be decided on the basis of the Plascon-Evans rule, a rule which has become known in South Africa these days as a result of some proceedings in the Judicial Service Commission. The second premise of this application is the acceptance on the papers that the appointment of the late Queen as a regent and her appointment or impending appointment as the monarch, the Queen, pursuant to the King's will, have been subsumed by other things. Her appointment as a regent has been supplanted or subsumed by the decision of the royal family on the 30th of March. And you will find the minutes of that meeting in volume 4 at page 344. The minutes were attached in the initial answering affidavit of Mtwana Kapendanga. And the point was made even at that early stage of the proceedings, that there was a meeting of the 30th of March.
Okay.
You recall, my lord, that on the papers, what happened is that there was initially the reading of the King's will earlier on in March. Then there was a second meeting of the reading of the King's will on the 24th of March by somebody from Sanlam. Can't remember the name. Then soon thereafter, on the 30th of May, the meeting which I've referred to at page 344, was held by the royal family, in which the royal family decided that the late Queen will be the regent, pending the decision of about the inheritance of the monarch or the appointment of the king. And my lord, in that meeting, the applicant princesses were present. They commented and debated various names which were put forward. During that meeting, we addressed this at some length in the answering affidavit. And I do not intend, unless I take much of my time, I don't want to go take the court there. But the fact of the matter is that the Queen, the princesses, the applicants in this case, were there. The name of Mbonisi,
The meeting of the 30th.
of the 30th,
They participated in that meeting.
fully and even commented. Not just participate, comment. They are the ones who shot down the name of Prince Mbonisi when it was raised as a possible regent. They said, no, we don't agree with the name of Prince Mbonisi. We are of the view that this, in accordance with the tradition of the Zulus, the late Queen must be appointed. We deal with this matter because if we may, with the court's permission, linger on this aspect, because it is of some significance. the princesses in this case, they are the ones who were talking in the meeting of the appointment of Mtanokos. We deal with this.
So where do you
page,
give it that?
at page 391, volume 5. If paragraph 83. Her Royal Highness, the second applicant, is reflected in the minutes. Unfortunately, the minutes are written in Isuzu, but the relevant portion of the minutes is quoted in full at paragraph 83. The second applicant, Princess Dombuzosutu, Zulu Dum, reflecting on the custom which I have also outlined, that is the fact that the late Queen was of Zulu royalty, of Swati royalty, indicated that since the late Queen had been identified by Isilo, there should be no debate or problem about the method of succession. In this regard, she says the following: Izinyane, that's the record of the meeting. Izinyane untombuzosudu wakakhetha umthandayo wabuza ukuthi njengoba umntana enkosi ekhonjiwe Isilo futhi nangakosiko ezaba ebukhosini, pho ngabe yini enza sibe nenkinga? When she said this, my lord, she was at her glory, because she was right in every sense of the word. Something must have happened in between. But my lord, that is the context. That is the context in which Prince Mbonisi's name, which was initially mooted as a possible regent, was shot down. There was another name, by the way, my lord, the name of Umtwana Wasekwez, who was also suggested as a possible regent.
Umtwana Wasekwez is not the one, the same person, the Prince Mbonis.
Is the same? Oh, say, my lord.
That's one person.
My lord, Badinga Bandwana said this in detail. My lord, the point is, there was debate about this issue. And the issue of the appointment of the late Queen as the regent was subsumed by a decision of the royal family. That decision by the royal family completely rendered the significance of the king's will irrelevant, because the appointment of the regent subsumed it. The other fact which subsumed the king's will was the death of the queen. Before she was installed as a regent by the institutional respondents, the premier or the president, she died. So the significance of the will was spent when what it thought would happen about the throne did not occur as a result of the passing away of the late queen. So to what end, we ask the question, to what end will the impeachment of the king's will have any bearing whatsoever to the appointment of the King Mrs. Zulu? Nothing whatsoever.
So in other words, are you saying the queen passed away before she could be formally appointed the successor or officially appointed the successor?
As a monarch,
Yeah.
in accordance with the provisions
So
of the
in
King's
other
will.
words, she never reached that position.
Yes. What intervened between the execution or the reading of the will or the death of the late king and her suggested or recommended or appointment by the king as the successor to the throne did not, in the middle, she died. And that never took place.
So now how did she appoint Prince Mrs. Zulu? In what capacity did she appoint?
In her capacity as the appointed regent in accordance with customary law. When the decision of the royal family was made to identify her and appoint her as the regent at customary law, she was already on the throne, albeit as a regent.
Can you refer me to the relevant portion in that one?
Sir Malone,
Can you refer me to the relevant portion of that?
of the affidavit.
Yeah, where she says what we are saying now.
Yes, my lord, the chronology.
She was nominating him in terms of the Zulu customs.
Yes, my lord. You know what happened is that she reflects on this, my lord, herself in the letter which she wrote on the 23rd of March. If I may ask the lordship to go to page 332 of volume 4.
332.
Yes. Before she could be installed, she spoke through the letter during her lifetime on 23rd of March.
Okay,
And we know this because
332. Okay, let's see what then. That's why we find the letter of the 23rd of March.
yes, 23 March. She says, His Majesty the King, during his lifetime and through his last will and testament, bestowed upon me the singular honor to succeed him and to assume the role of the throne. And then she says in paragraph 5, whilst I am humbled by the honor and the wishes of His Majesty, I believe it to be appropriate and befitting of the great Zulu nation to bestow the honor given to me by His Majesty to my son, Mtwana Mrs. Zulu. In this regard, I implore you to give consideration to appointing Mtwana Mrs. Zulu as the king in my stead. She spoke through that letter and repeated this in her own last will and testament, which was very honorably read at the memorial service.
What did she mean by saying that they should give you consideration?
She was, in our submission, my lord, she was saying to the royal family or to the reader, the people who ultimately read, to whom the letter was read, to say, please, I nominate somebody else.
So then it rested with them whether they accept that person or not, or they did not have a choice. They have to abide by her wishes.
No, not really. I will come to that argument. The point of it is that she said, I accept what the king has said. It's good enough, but I think, in my understanding of the customers' law, and she set it out in her letter. I don't want to read the entire letter because I've had the occasion to read it before. She says in her letter, I know I was bestowed by the king the honor to be the monarch. I nominate my son to be that monarch in my state.
So,
and because, and she sets out the reasons in the over the page 333, 5 reasons why she says, in terms of the Zulu customary law, that is actually the right person who should become the heir to the throne, and she outlines them.
She was correcting the will of the king.
Effectively. But as the queen and the monarch, her word could not be disregarded unless if it was inconsistent with customary law. In the same way that the royal family would not disregard the wishes of the king if they were consistent with customary law. Now, my lord, but also, my lord, even if the queen herself had got it wrong on the customary law, the royal family will have a latitude to correct her when considering the matter. And that is exactly what happened. And we don't have to speculate what the royal family did or did not do. We have it on record. It is at paragraph 27.2, it's volume 5. It's been read at page 372, volume 5, paragraph 27.1.
372.
– 27.2, paragraph 372, where His Royal Highness Prince Mangosuthu Buthelezi says, the expression of the late king and the late queen's wishes in the form of a will or a testamentary instrument or a letter confirmed the known position at customary law, and that is the late queen's eldest son would succeed the late king. That was the expression of her understanding of the position of customary law. And in paragraph 41, this point is taken up when the Buthelezi says, as a matter of customary law, the wishes of the king or a queen about who should succeed him or her is important, but it is not decisive. And later at paragraph 49, Prince Mangosuthu says, those wishes, the wishes of the king and the queen as to who would be their successor, those wishes evince the king's own understanding of customary law applicable to succession. As the king is the traditional, customary and cultural leader of the Zulu nation's customs and traditions, his wishes are a strong indication of the customary law position. Indication. But my lord, we don't have to really second guess what the position of customary law is. It's been expressed by various authorities. I know, my lord, you have written on this aspect, but to save others the trouble of thinking that you are the only one who have said that, my lord, in our heads of argument, we set out various authorities, principal among whom is the learned author T.W. Bennett. It's quoted, the passage is quoted in full at page 65 of our heads of argument, paragraph 151, where he says, regarding the topic of the appointment and the successor of the office. The legends and traditions of most South African chieftaincies regard the first person to settle the law as the founding father of the nation. Thereafter, according to the principle of patrilineal succession, his office was inherited by his eldest son. If deceased, the ruler had contracted a series of polygamous marriages. Her heir will be the eldest son of the principal wife, whose rank is usually denoted by the fact that subjects had contributed towards the payment of her lobolo. Can it not be so clear? Continuing on this subject and zooming it in on the Zulu nation, the learned author says at page 245, a wife's rank is usually determined automatically by the time of marriage, but it could be varied by a public declaration, which the husband may make at the time of the wedding, or even later, provided that the status of existing wives is not upset. A woman's social position before marriage may have been a marked effect on her rank within the husband's household. Then he says, with the Zulu, for instance, a woman of an aristocratic family takes precedence over other wives. A woman of aristocratic family. And I do not want to quote the authorities which come thereafter, because another author writing by the name of Dondo, writing extracurrially, that's your lordship, embellishes this point and says, and I don't want to read that to my lord, because it reinforces the argument, the points made by the other authors on this topic. That is a decisive factor.
Well, that's the statement of law.
My lord?
You read what is in law.
Yes, my lord.
If that is in part of the law, can read it.
The learned author on that topic, my lord, is quoted at length in the paragraphs at page 66 of our heads of argument. The learned author, my lord, speaking extracurrially, says the status of the mother of the person who intends to ascend to the throne or to be appointed king or inkosi is a decisive factor where the deceased king or inkosi had more than one wife. Decisive factor. And it continues to say,
where is that found in your papers?
In the papers, my lord, we deal with this at some length. We are really in that territory.
What are you reading from?
My lord?
You were reading from something there.
I was reading, my lord, from the heads of argument.
Yes, where in your heads of argument?
It's page 66. The authorities that I read, my lord, they start at page 65 of the respondents' supplemented heads of the argument, and the paragraphs I read from is paragraph 151 when I referred to Bennett. The authorities relating to your lordship's book are in paragraph 153 at page 66. So, my lord, on the facts of this case, which are set out in the following paragraphs of the heads of argument, we set out the very fact, and it is asserted by Umtwana Papidangani in his own affidavit, that the fact that the late queen was married from the family of the royal family of Eswatini granted her preeminence, with the result that her first son was preeminently the heir to the throne. So, my lord, in a sense, when the king died, when the late king died, the position of who was going to be the successor to the throne was already predetermined or settled by the very fact of the king having married the late queen, and in the manner in which she was procured as a bride by the Zulu nation. And all of these facts are set out in the affidavit by Prince Mangosuthu Buthelezi. I can take my lord to those papers. They are set out in our heads about it.
No, if they are in the heads of argument, don't repeat them.
Yes, my lord. And I think it is an indisputed fact that she, the late queen, is the daughter of the late King Sobus II, and that she was married. Before she was married, the entire Zulu nation gathered ilobolo for her to be procured to be the bride of the king. It is undisputed that she is the mother of King Misuzulu, and King Misuzulu is the first son born out of her womb. So, my lord.
So, what do you say to the argument that she appointed Prince Misuzulu as the king of the Zulu people on the strength of the king's will?
No, she didn't. She did so because she was already a regent at the time. She had been appointed as a regent. My lord, she could literally have appointed, she could have been any other queen nominating as a starting point. But as soon as that served before the royal family, the royal family's decision subsumed anything else before it.
So what is your submission to the argument that any member of the royal family can come up and stop the process simply because she's a member of the royal family and nothing more to that?
Well, look, our response to that submission is simply this. Insofar as locus standi is concerned, yes, of course, any person can approach the court because he has standing. But if his locus standi is grounded on the fact that he's acting for himself, he must then say something more than a person who is articulating the rights of a general body of people. Now, this issue, my lord, was decided, I think, the issue of standing. There's a distinction on standing grounds between a person who is acting in his own interest and a person who is acting in the public interest.
So would you say the princesses are acting in their own interest or in the public interest?
But they say something about it.
No, particularly with regard to succession.
With regard, in their founding affidavit, they say they are acting in their own interest. In the founding affidavit. Because it is there that they must make out their case. You will find this, my lord, at paragraph 4 of the founding affidavit, where they assert their own standing. But my lord, it ultimately doesn't matter, because even an NG...
So what do they qualify to do so?
They have standing, but if they want an interdict, they must do a little more than establishing standing. They must establish a protectable interest which they seek to protect by way of an interdict. And what is that interest? That is what this case falls flat on. The interest which they protect is not an interest. In terms of Section 17 of the Khoisan Act, Section 8 of the Khoisan Act, and Section 17 of the KZN Act, which regulates the identification of kings, you can only create a dispute or can come to court to protect a particular outcome of a dispute resolution process if you allege or produce evidence as to inconsistency with customary law in relation to any identification. That's the only limited ground upon which you can come to court and ask for an interdict. To succeed in an interdict, you must say, as an applicant, I've come to court because there is an identification of a particular person that is not in conformity with customary law. That's because, my lord, that is exactly what the Premier and the President is required to investigate. The Premier and the President can't investigate anything or any other person's allegation that I can be a king. I myself do want to be a king, but I just can't come to the Premier and say, please stop the appointment of King Mrs. Zulu or Prince Mr. Simarate as the king because I also want it. You must say more than that. You must say the appointment of Advocate Madonsela as a successor to the king or the monarch is one that accords with customary law, and these are the reasons why that person is eligible. So the process must be stopped so that the resolution of that dispute can be entertained by a person, either a court or the Premier. But you can't come to this court and seek to interdict the identification and the recognition of a king in circumstances where there is no process in place that will be followed to see through that dispute.
And we are not going to be adversely affected by the appointment of the king.
That is what Mpepo was all about, because Mpepo was saying you must actually, at that early stage, identify the adverse interest or right that will be affected if a decision was to go forward. It is only at a later stage that you can actually resort to other remedies. But we are not there. And in fact, my lord, the Malala friend has made a submission just before he sat down that there has been an identification of Prince Simarate as a possible successor to the king. But no, that is entirely incorrect. He makes reference to the supplementary replying affidavit, which was filed after the heads of argument had been delivered. What happened, my lord, we set out the history of the event. In that regard, my lord, maybe I should pause and again linger for a moment to give you the chronology of events and how this litigation unfolded. Because it's being suggested now that Prince Simarate may have declined because he was afraid that there's been no, that he was not going to object because somebody, the Isilo had said something.
How is he going to decline or be afraid if he's entitled?
That's the point, my lord. The point I'm making, if you look at the chronology of events, we set out the chronology of events, my lord. It's at page, in our heads of argument, at page 54.
So before that, is Prince Marade born of the late queen?
No.
Who the mother of Prince Marade? Amongst the 6 queens, who's the mother of the Prince Marade? Prince Marade?
None of the queens are the mother to the Prince Simarate.
None of them?
None of them.
So on what basis does it claim entitlement?
That is exactly the point, my lord, we are making. We're saying if Prince Simarate, in fact, my lord, even before we get into examining who is Prince Simarate, we should examine what Prince Simarate has said himself, because we don't want to second guess what he said. He said, when, but Lord, the chronology of the events is this: 28 April, this application, Princess's application, was launched. It was due to be heard on the 7th of May, but literally on the day when it was launched and it was served on the Queen, she died. And on the 6th of May, the application was removed from the roll. Now, on the 14th of May, let me start by saying, on the 7th of May, there was a reading of the will, which is a matter of public record. Somebody eminent read the will of the last Queen. And then on the 14th of May, there was the family meeting, the royal family meeting. Now, on the 17th, shortly after the royal family meeting, which I've dealt with, about the identification of Mrs. Zulu, there was this application, the urgent application by the princesses was re-enrolled in court on an urgent basis to deal with that very issue, the fact that Prince Mrs. Zulu had been identified as the king, because it was believed, at least in the media, that his appointment as the king was imminent. That was what necessitated an urgent re-enrollment of the princess's application. So the fact that King Mrs. Zulu had been appointed or identified at the royal family meeting on the 4th of May was known and was the reason for the princesses to bring an urgent application on the 17th of May. The matter came before your lordship, and your lordship, what happened, my lord, before that? A day before, the matter was set down for the 21st of May. A day before that, Prince Mangosuthu Buthelezi delivered an interim answering affidavit, which you will see, my lord, at page in volume, where is it? Which you will see appears in volume 4 of the papers from 290. In that, it is in that interim answering affidavit that Prince Mangosuthu Buthelezi produced the minutes of the 14th of May. They are attached in that affidavit as at page 348 as PMB 7. Around that time, my lord, and I asked the lordship to go to volume 6.
Have you not taken more than what you deserve to take in terms of time?
Sorry?
Have we not taken more time than we deserve?
Oh yes, my lord. I wanted to make the point. The point.
Well, I'll give you 5 minutes to round up.
No, my lord, the point. All what I'm saying is at paragraph 133 of our heads of argument. 133 of our heads of argument. The point of it is that it was on the 11th of May that Prince Smarate wrote a letter and asked Mtwana Pindangani to publish it for the whole world to know, in which she says, or rather he says, I am aware that there are talks which include my name, that I, Simarate Jackson Zulu, is aspiring to sit on the throne. I was pleased to see that on television, the prince, referring to Mtwana Pindangani, made it clear that I have never expressed such ambition to him. I myself wish to attest that. I wish to assure everyone that I have never expressed such ambition to anyone. She was served with the minutes of the meeting of the royal family subsequent. And my lord, she delivered an affidavit.
Sorry. But it is being said now by the princesses that he has that ambition That's why they want to have the processes stayed.
My lord, she delivered, Prince Smarate did not stop there. He delivered an affidavit in these proceedings. These proceedings. His affidavits are part of the papers here. His affidavit is to be found. He should not be spoken to on behalf. People should not speak on his behalf. He has spoken himself. His affidavit is to be found, my lord. Where is it? Oh, there is it. It's volume 3.
What page?
That's page 269.
Yes.
He does not say any of the things that are attributed to him by our learned friend in argument today that he could have done. He is aware, he was aware by this time that the prince had read out his statement in which he declined. He does not say, because this affidavit was delivered on the 18th of June. He does not comment on Prince Butere's statement that he has declined eligibility to the throne. And Prince Buteles went on and said he is aware of no dispute or anyone who is eligible to ascend to the throne. Prince Smarate was aware because he's referring to the affidavit in his answering affidavit. He's also referring to the affidavit, the supplementary affidavit of the 16th of May. I'm sorry, my lord, his affidavit was delivered on the 20th of May, sorry. Just to correct myself. Just before the Mangosuthu's composite answering affidavit, but Mangosuthu Telesi had already delivered an interim answering affidavit disclosing the minutes of the 14th of May. He was responding to that. When the matter came before your lordship on the 21st of May, you granted an order, my lord, asking any of the respondents, that the order is set out in the notices, asking all the respondents who wants to oppose on any basis to deliver further affidavits. Smarate didn't take that opportunity. Nor did the princesses try to supplement their papers. So, my lord, and so did Monisi, Prince Monisi, by the way, who was also party to these proceedings. So, my lord, we submit that Prince Mngate has not placed himself in the race. He has not thrown his hat on the race. And the reference to the...
Okay, let me ask you about this, because this we have exhausted. Is there any preparation for coronation which is underway?
No. Well, my lord, I think you are asking the wrong person. There is somebody from who's representing the Premier and the President here. He has said in previous proceedings that there's...
Because this, the princesses also, they talk about the coronation, it should be interdicted.
My lord, the coronation is, as I said in the heads of argument, is in the tier, in the 5-layer tier process that is set out in the legislation. That is almost the last step of the entire chain of events. We are not even there. It must be preceded first by a proclamation in the government gazette for the recognition of the king. Then you would know that it is imminent. Before that, it cannot be issued.
According to your knowledge, there's nothing which is being prepared.
My lord, we are nowhere near that. No, we would not prepare it because, my lord, it is at the instance of the Premier. It is regulated by Section 17 of the KZN Act. It's the Premier who arranges a special ceremony for that purpose. So he would inform us about it, and then we will comply with his requirements. Once a recognition process has taken its place.
Have you been informed?
We have not been informed on the instructions we have. And on these papers, there is no basis for thinking that we are anywhere near. What we have now, my lord, is some skirmishes about mediation by the president, which has been put up in supplementary replying affidavit. A process which has got no statutory place. It's just a mediation because it's good to mediate things. What is awaited now is for the president to make a final decision on the basis of the minutes of the 14th of May and further minutes of meetings of the Royal Family which took place on the 29th of September. That's where we are. And we hope that the president will do the right thing.
All right, thank you.
Those are submissions.
Any other person?
Lord, I've got nothing to add to what's been said by Mr. Ferguson.
I think we have to reply so that we have Mr. Njogu.
Yes, but Lord, might I take your
Who is
lordship?
on left.
My lord, can I start with the locus standi point, my lord?
Is that yes?
Locus standi point.
You have
Locus standi?
You have a locus standi.
No, my lord, there was an argument relating to the locus standi.
Yes. Okay.
Might I take your lordship to page 228 of the bundle of documents, my lord?
228 of.
It's the supplementary affidavit, volume 3, my lord. They make out certain allegations relating to their rights under the main founding affidavit. In the supplementary affidavit, these are expanded upon. My lord. Paragraph 67. I'm going to read it out as quickly as I can. My lord. In this application, I assert my rights under sections 9 of the Constitution. Section 9 provides for the right to equality, which advocates that everyone is equal before the law and has a right to equal protection and benefit of the law. The KwaZulu-Natal Traditional Leadership and Governance Act provides for a procedure to be followed when royal families has to fill the position of Isila. This procedure entails a democratic process wherein the family participates in identifying a person to be Isila. On Friday the 7th of May, Prince Zulu was announced at the occasion commonly referred to as the reading of the last will. My lord, I'm going to then jump. Paragraph 71, she says, in essence, as a member of the family, I was denied the right to participate in the identification of the future king of our kingdom as the Zulu Royal Family. I say this process infringes upon the right to equal benefit of the law. Section 17 of the KZN Traditional Leadership and Governance Act confer upon me as a member of the Royal Family, the Zulu Royal Family, a right to choose or identify the person to be named as a successor to the throne. In this respect, the manner in which Prince Zulu has been elevated to the throne infringes upon my right under Section 9 and also infringes upon my right as a member of the Zulu Royal Family. My lord, this theme is expanded on further into the supplementary affidavit. I'm not going to read to your lordship all the provisions, but as a member of the royal family, she had a right to participate in the process, and she has a right to participate in the process. The identification of the future king is something which is greatly is adhered to, my lord, and confers on the right of the members of the royal family to participate in the process.
So what that will mean, every Zulu citizen may have a right.
You have a right to participate in the process.
Yeah, they have a right to participate in the process. I agree with you.
Yes, and if the process is flawed,
what right does she have to bring this proceedings?
my lord, if the process is flawed, that's the only right she would have. If she can establish that there is some irregularity or deficiency or flaw in the process, my lord, then she would have a right to approach the court and ask the right to protect her rights and interdict the process until those rights are remedied. And that is what she's saying. She's saying there is something in this process which is flawed. the flaw in the process, and it emerged clearly from my learned friend's argument. The process was the late Queen nominated the late King nominated the late Queen to be his successor. Now, my learned friend indicated that on the 30th of March there was a meeting at which one of the princesses, who is an applicant in this matter, acceded to the late Queen being appointed as the regent. Rightly so, my lord. At that point, there was no challenge or question as to the validity and authenticity of the late King's will. That had not arisen, my lord.
But he also proposed that Mrs. Zulu should be identified and appointed as a successor in terms of the customs in the very same meeting.
My lord, the Queen identified, my lord, not the princess.
That was read even in Zulu to us.
Yes, my lord, but not the princess.
When the princess was saying that, no, why should we wait? Because in terms of the custom, the person who's entitled is Mrs. So
it's a person identified by the King.
Not by the King. A person who's identified by the custom.
My lord, I'm just going to get my information.
Mr. Matonsela read that thing. It's at
my learned friend is busy consulting. Mata indicated maybe my learned friend can also consider that the issue of how the meeting of the 14th of May was convened is dealt with at volume 5, page 394.
Volume 5, 394.
Paragraph 93. It was not just, according to the version of the respondent, it was not just a cleansing ceremony. Prince Sibongiseni Zulu was tasked to call all abantwana izigodi zindlu zasondlunkulu, and they were called for that purpose. He confirms it. Now, if this matter is to be decided on Plascon Evans rule, then that version must prevail.
Okay. That is volume, Mr. Redman. Are you still with us?
Lord, in regard to my understanding of that paragraph that was read by my learned friend is absolutely nil. But my attorney and my...
It's absolutely nil.
My Lord?
We read that paragraph. This paragraph is volume 5, the page 391, paragraph 83.
My Lord, the paragraph, as I understand it, and my Lord, your Lordship will find it, page 391 is referred to in the affidavit. My learned junior's understanding is that related to the appointment.
And if you read the last portion of it, where she says this thing, maybe someone can interpret for you, or translate it for you, but that's what she says there. That is verbatim in any way. That is quoted that she said. But now she's saying something different to this.
My Lord, perhaps my learned junior can argue this particular point.
May please support my correct interpretation of paragraph 83 is very simple. The word Umtalenkosi which is referred to in this paragraph refers to Prince Misizulu's mother, not to King Misizulu. So that is the first anomaly, my lord, if the court is persuaded to accept this, because this meeting was preceded by the event of the 23rd of March, where the Queen purports, acting on the authority of the will, to appoint King Misizulu. She did not act, my lord, on the authority of the meeting of the 30th.
So now, if she proposed that she must be appointed, why she's complaining now that she was appointed in terms of the will? Because she attended the meeting and participated and made some comments as to who should be appointed.
Well, let's get the sequence right, because it appears that the court somehow may have got the sequence wrong. The sequence is as follows, my lord. On the 19th of March, the will of the late Isilo Ubayede is read to the family. On the 23rd of March 2021, the late Regent Umdane Nkosi writes a letter which is attached to the papers of the respondents and says, and my lord underline and emphasize, this is before the meeting of the family. And I ask my lord to underline that important aspect.
No, I'm asking you about paragraph 83.
My lord, paragraph 83,
Not
my
the
lord, was
sequence.
misplaced in the approach the court seek to adopt. Because this is a meeting about the nomination of the Queen.
Okay, that's what I'm saying, that if she participated in the meeting of the Queen, why is she now complaining that the Queen was appointed in terms of the will?
Well, she participated because the Queen was identified in the will. And at that stage, the investigation has not been initiated. And my lord, I ask you to underline those fundamentals. A person who challenges the validity of a document may not at any point be denied a right to challenge the provisions of such document. And it would be absurd to suggest at bare minimum that because I participated in a meeting of the 30th, I am denied a right to challenge the correctness, validity, authenticity of a document that purports, and that is a fountain of what all that follows.
We are talking past each other. You don't get what I'm saying. I'm not saying that she must be denied. I'm saying because she was present and she also participated and proposed that Mtwane Nkosi should be appointed. Why now she turns around that Mtwane Nkosi was only appointed on the strength of the will? That's what I'm saying.
She argued on the understanding and the respect of her late father Ubayede and said, the guidance we've been given as Amazinyane Esilo is simple. Respect what the elders have said to you. And my lord, there is no other way. The papers of the respondent hold that view throughout. And she says, why should we depart on what is readily identified by Ubayede? And what was identified by Ubayede at the time is simple. I must be succeeded by the later. But later on, my lord, as events are before you today, there's a challenge on the validity, there's a challenge on whether or not the will is valid. Now, my lord, you cannot then escape that until that question is determined, the foundation and fountain of authority of the late Queen to make the nomination on the 23rd is under question and under scrutiny. But my lord, there are two more things we wish to submit. The first...
But unfortunately, I can't remember your surname.
My lord, I apologize, it's Tulu, initials MN.
Okay.
I'm just slightly...
Yes, Mr. Tulu.
Yes, there are two more points, my lord, we wanted just to emphasize. that are before you are very streamlined and clear. Paragraphs A, 4A and B says to this court, interdict the execution of the will until it is determined if it is valid or not.
No, that is clear.
That is 4A and B. But in that will, my lord, what you cannot escape is paragraph 15. In that will, that you cannot escape, my lord. That paragraph 15 says, I bequeath the throne and I appoint somebody to that. And my lord, if we are together and you are with us on that point, and you are with us that paragraph 4A and B are clear as the sunset follows sunrise, you can follow that even the effect of paragraph 15, the source of the late Queen's nomination, if it is suspended, her nomination on the 23rd of March, before she was even acknowledged by the family, is questionable. But also, my lord, as you deal with this matter, the court must be cognizant of what is set out in the princess's supplementary affidavit. The events that...
I don't think that now you must have exceeded the time limit. Because according to Mr. Redman, we were just asked you to address me on the issue of the princess who attended the meeting. But now you seem to go on now.
I apologize, my lord. My lord, I have no difficulty, my junior, finishing the argument.
All right. Is anybody else want to say something? Yes, Mr. Ndobu, because you also brought an application to stay this proceeding, but unfortunately I don't understand your application.
My lord, our application was premised on the rumor that were circulating around that there was a scheduled coronation set down for or planned for the 3rd of December. And we were of the view that that cannot take place pending the determination of the dispute which was set down for the 7th and the 8th of December. So we were saying that if the coronation which is planned is to take place, it will render now this proceeding moot.
So then they wanted this court to act on a rumor.
My lord, the rumors, the reason why we ended up in court, we did not just jump and come straight to court. We wrote a letter to the first respondent, Prince Mrs. Zulu, and the second respondent, Prince Mangosuthu Buthelezi, to either deny or confirm the veracity of the rumors that have been circulating around. And my lord, you must understand that since the demise of the late Silo, the family is divided. There is no proper flow of information. Now, there will be rumors flying around, and we then approach the relevant persons to either deny or confirm, and they did not respond to our letter. And on the basis of the lack of response, we then approached this court. And it was only after we approached this court, or in fact it was on the date of the hearing, that we were then told by the representative of the Premier and the President that one, they are not aware of the planned coronation. To their knowledge, there is no such thing that is been planned. And that was also confirmed now in the answering affidavit by Prince Mangosuthu Buthelezi, that there is no such thing that has been planned. But however, my lord, what they did was to confirm that there is a process, the process is ongoing.
Did you approach the Premier's office?
My Lord, we did not approach the Premier, and the reason why we don't approach the Premier was simply because that for the coronation to take place, there has to be, firstly, a process that has to take place from the royal family. Because if you look at the 5 tiers that has been set out, the Premier and the President come at the last tape. And it's not in dispute that the crawl has been prepared. Prince Mrs. Zulu is being ushered into the crawl, where he's going to be introduced to the ancestors as the next king.
Just a minute, Mr. Ndogo. I think you must be conversant with KwaZulu-Natal Traditional Leadership and Governance Act number 5 of 25. Are you conversant with that?
I am conversant with that.
And section 17.5 of this act provides the following: the Premier may arrange a special ceremony to enable the sealer to affirm his allegiance and faithfulness to the Republic of South Africa and the province, and to obey, respect, and uphold the Constitution of the law. It's not the royal house or the royal family.
But my Lord, yes, we accept.
You must have known this.
We accept, my Lord, that the Premier and the President come at the last tape. And we're saying, my Lord, that from the rumors that we've heard, the process, the family processes are already taking place. Meaning, the Prince Mzulu has been nominated. His name has already been submitted to the Premier. He has been ushered now to the crown by the family, to the which process is meant to introduce him to the ancestors as the next king. And now we're saying that because that has taken place, now it is clear that the coronation is about to take place.
But there was a very same application before court by the 2 princesses, asking for the same relief. Why is it necessary for Prince Mbonis to bring this application?
My Lord, remember, if you look at the application by the princesses, there was no date attached. They make reference to the coronation that is being arranged, but there was no specific date that was mentioned. When we came to court, we came with the date to say, from the information that we have gathered, the date has been set, which is the 3rd of December. So it is for that reason that we were in court on the 2nd of December to interdict what is about to take place the following day.
But we are now in January.
My Lord,
we are now in January. No coronation has taken place. No arrangements have been made.
My Lord, hence,
what shall I make of this?
My Lord, hence, on that day, your late brother did not. We on the basis of his understanding of the papers, and obviously based on the undertaking by the President and the Premier, that there is no such thing that is taking place. It was agreed that the court will not even make a ruling on whether that is interdicted, as it is not. There's no information that it is indeed being planned. However, the court was of the view that if the regard is held to the other prayers, in particular prayer number 4, where we say if in an event that the process has already taken place, such process has to be interdicted. The court felt that we need to be joined in this proceeding, so that the court on the 2nd does not steal the show from this court.
Okay, Mr. Ndov, we now know that there's nothing of that sort. What you want us to stop?
My Lord, we accept that there is no coronation. We take the weight of the President and the Premier that there is no coronation that is taking place. We accept, my Lord, that as a lordship will look at our notice of motion, all what we were intended to do was to stop the coronation pending this proceeding taking place. Now we accept that now these proceedings are now, the trains already have left the platform. the telephone motion. Now this matter is now being entertained. Therefore, this court will be then in the position to make a determination on whether the process is interdicted or not. So we accept our relief is already now moved.
The horse has bolted.
Yes, bolted. That we accept, my lord. But unfortunately,
So, but before we come to this thing now, does Prince Mbonesi has any local standing to bring this application in the first place?
my lord, we'll submit that he does have a local standing. As a core member of the royal family and as an elder, one of the elder member of the royal family, he has all the rights to come to this court. And in fact, if you look at what he was seeking, my lord, was to want to stop this abnormal situation that is about to take place, and to somehow, I will say, to level the playing field. So his interest was to say, there is a day that is set for the hearing of this matter. Why must we then allow the coronation to take place? Because now, if it does take place, it will render now this proceeding now academic.
Okay.
And my lord, we submit, and though this local standing is being challenged by the respondent, and my lord, I will submit, my lord, with the grace of respect, that it is so disappointing that the second respondent will challenge the local stand of Prince Mbonesi on the basis that his mother was not married to the king. My lord, do we know that there is no discrimination on whether this is an illegitimate child or legitimate child? Everybody is equal before the law. And the fact that he's born of the royal blood, whether it's from his mother was not married or was married to the late King Cyprian, it does not change his claim to the royal family.
Yes, that is correct. But he must have been mandated by the family to bring this application. Is there any mandation for?
My lord, you will
is
see,
there any mandate?
you will see on the founding papers that there are confirmatory affidavits that are supporting affidavit by some member of the royal family who are supporting this application.
Okay.
So it is not only bringing his application on his individual capacity, but that application is also supported by some member of the royal family, who I submit, my lord, their claim is not being challenged.
Is there any dispute with regard to succession?
My lord, I will submit that there is a dispute with regards to succession, and in particular the nomination of Prince Mrs. How he was nominated. We submit, my lord, that process is flawed. My lord,
in which sense?
My lord, if you look at, I will confine myself to the meeting of the 14th. Of the 14th of May, 2021, where there's a royal family meeting. If your lordship have regards, and your lordship has been referred to those minutes of that meeting, where your lordship will see that Prince Mangosuthu Buthelezi calls the meeting. He introduced the purpose of the meeting, and he introduced the king, Prince Bizulu, as the king. So the meeting was not to nominate. The meeting was simply to introduce, because you will see, my lord, that there's no agenda for that meeting. It's a meeting, there's a welcoming, opening. Now there is a purpose of the meeting that is now, for the first time, is then said that is for the introduction of Prince Mrs. Zulu as the next king. and then we see that there's some royal members of the family members who then support that. So, my Lord, we cannot say in terms of that process is in compliance with the Khoisan Act as well as the KwaZulu-Natal Leadership and Governance Act, because it was simply for the members to be told to be introduced. So you cannot say that it was a nomination, because the nomination, there has to be nomination, and there has to be reason why this specific person is nominated, and that person must be open to every member.
Is there anybody who claims a better title or entitlement to succession,
My Lord,
other than Prince Misuzu?
My Lord, even Prince Misizulu he did not raise his hand. Prince Misizulu was nominated, was identified and introduced. So the person was not open to everybody to participate. Your Lordship, if we were to go back now to the meeting of the 23rd of March, you will see that the press was open to everybody to participate. Names were thrown, people made comments and made counter suggestions. But with this one, it was simply for the people, for everybody to be introduced, for individuals to be introduced, and for everyone to accept that this is the case. And we say, my Lord, that in fact we cannot even run away from the fact that what ultimately transpired on the 14th of May was to rubber stamp what is already in the will of the late Queen.
But I hope that at last you will answer my question, because you have not done it now. My question is, according to your knowledge of your client,
Yes.
is anybody who has a better title, right, or entitlement to succession other than Prince Misuzu?
My Lord, for now, there is nobody who has raised his hand. But my Lord, we are saying that if this process is interdicted and it referred back to, and it's open to every member of the royal family to participate, your Lordship will be surprised that there will be other members who raise their hand and want to be appointed or nominated as...
Well, that's not a political meeting. There's a procedure which should be followed when appointing somebody or identify somebody for succession.
Yes.
And people who are being identified, they must qualify.
Correct, Lord.
Not every person, because he happens to be a king's child, is appointed. It's not like that.
No, my Lord, yes, the criteria will have to be set.
Yes.
There will be a criteria that has to be developed by the
No, not to be set. It's set by the law, customary law and tradition. That is set by customary and tradition. That's why even the Act insists that it must be in accordance with customary law and customs.
And the Bill of Rights.
No, there's no Bill of Rights in that.
Absolutely, my Lord.
If you add the Bill of Rights, it's okay, because people must participate and so on.
My Lord, it's in the Act.
In the Khoisan Act, there's nothing like a Bill of Rights.
My Lord, in a paper matter, it's set out that it must be that there must be criteria, and that criteria must be in accordance with the custom and the customary law and in line with the Bill of Rights. Is there more that can...
What is not in line with the Bill of Rights?
My Lord,
because in terms of Section 30 and 31 of the Constitution, the Zulu people are entitled to practice their own culture.
my Lord, I will refer your Lordship to paragraph 15 of the judgment of the paper, the Constitutional Court judgment, my Lord.
Yes.
My Lord, it's paragraph 16. It's paragraph 16 of the judgment.
Is the people following the same culture as the Zulus?
My Lord, it says it says the criteria that there must be. And let me read that paragraph, my Lord. Paragraph 16 reads as follows, my Lord. Fourthly, the Supreme Court of Appeal held that the criteria applied by the Royal Family Council in making the identification decision, as set out in the minutes of the selection meeting, endorses gender discrimination in that it prescribed that one, people Ramabulani family, in particular the chief or the king, must come or must be a man or a son. The court declined to declare the criteria itself unconstitutional and invalid, or to review or set aside. On the basis this court decision in Shilubane held that the community should be given an opportunity to develop their custom and tradition as to promote gender equality. It was held, however, that the identification decision and the recognition decision failed to be reviewed and set aside because they were made in terms of criteria with an effect of impending compliance of Section 2, capital letter A4C of the Framework Amendment Act, which imposes an obligation on the Royal Family to develop a criteria for the identification of suitable person for the throne and to bring that criteria in line with the Bill of Rights. So, my Lord, the Act says the Royal Family must develop a criteria, but that criteria must be in line with the Bill of Rights.
What is not in line with the Bill of Rights in this case?
My Lord, I'm saying, my Lord, that when we say Prince Mrs. Zulu is the only person, by virtue of the fact that his mother is from the royal family and therefore as a first son, therefore he qualifies.
You have said it yourself. Nobody else. You have said it. I will ask that question.
No, but my Lord, we are saying, my Lord, that process. If we have regards, my Lord, to Shilubane judgment, and what the framework was saying, and what the Constitutional Court is saying in Ramabulani, it cannot be said that identification nomination was above reproach.
Yeah, but the procedure is set out in the Act. What to do? We have to lodge a complaint, but we have to state that person was not appointed in accordance with the customary law and traditions. And more to that, you must say who's entitled, who has got the better right, on what grounds. The procedure is set out clearly in the statute. It's not that the person should come to court.
But my Lord, it does not say. It does not say that the successor must be a person who's born of, or his mother who's from a royal family. It does not say that.
No, that is a Zulu custom.
Yes.
And every nation has got its own custom, as the law, the Constitution protects those cultures and customs.
But my Lord,
we cannot nullify the Zulu custom because of the Mpepu matter, which is not related to what we are dealing with.
My Lord, I say the Mpepu matter is directly related to this matter, in the sense that it challenged the nomination process. Because what we are challenging here is a nomination process.
Okay, in that Mpepu's case, they are challenging that some of the people they did not bear the Mpepu surname. It's not that.
That's correct, man.
But in the Zulu culture, it's different, because a child born of a princess could be Khoza, could be someone, could be Madondo, but that child is regarded as a prince or princess and part of the royal family.
But my Lord,
that's how the Zulu custom is. So I don't know what the Venda custom is.
But my Lord, we are saying, my Lord,
so in that instance, would you say the person bearing a different surname will not be a prince or princess?
My Lord, we are saying the allegation is that some people who were part of that meeting,
who are those?
Are not part of the are not the members of the royal family as defined by the Act.
Who are those people?
My Lord, there's a list that there's an attendance list register that is attached to.
But that should be borne by the papers, Mr. Ndlovu, is not so?
My Lord, yes, it's part of the record. However, my Lord, as we say that in our application, we did not want to venture into.
Okay, what relief do you seek now, Mr. Ndoro?
A lot, like we're saying, that we seek the interdict in terms of the process.
Interdicting who?
The decision to nominate Prince Mrs. Zulu as the incumbent.
Well, are the members of the late King's family joined in this matter? Are the Queens joined in this matter?
They are not joined, my lord.
So how can you go on, because they have got interest? They are the mothers of the nation.
My lord, they were not joined simply because there was no relief that was sought against. We were simply saying the process that led to the nomination is flawed. It should be referred back to the family for reconsideration. And in fact, as my lordship would have seen in our papers, we were simply interdicting what was about to take place pending the outcome of these proceedings, and of which the Queens are a part of this proceeding.
So now, do you see that the non-joined is crucial also? In the first place, there's nothing we ask us to interdict, because there's no coronation underway. That's the first thing. We also considered there's nothing. It was just a rumor. And secondly, there are people who have got interest, the Queens, who are the wives of the late King and their children. Are they joined? And are not joined. So how can Prince Mbonisi deal with this matter without joining those people?
My lord, at that time, we of the view that there was no relief that was sought by or on behalf or for the
Well, but they have a direct interest.
I accept, my lord, that they have a direct interest, and we're saying that they did not even themselves apply to as an intervening party who have an interest. And nothing stopped them, my lord, and we will submit that nothing stopped them from bringing application to intervene if indeed they had an interest on the relief that we were seeking at the time.
Also, there's something surprising. That the Prince Mbonisi is a respondent in these matters. He opted to abide, but now he's bringing an application on his own to support the applicants or to do something. I really don't understand, because this was part of the proceeding. Why now he's bringing his own application?
My lord, the reason why he brought that application alone and at that time was informed by the information that he received, and seeing that there was no action on the part of the princesses, it was now up to him to now take a stand and bring this application. As you can see, my lord, that in that application he was simply saying, I want this, if this coronation is indeed taking place, it should be stopped, because the matter is set down the following week for a hearing. So therefore it cannot, the coronation cannot proceed as scheduled pending or before this matter is heard, because the outcome of this proceeding will have a bearing on who subsequently become the king. And we were saying, let that person be stopped. So that's our relief that we sought about was very simple. To say, wait until next week. What's the rush? Wait until next week if this is happening. Then once the court has made determination, then everybody will be free to do what they want to do. And unfortunately, your brother did not make a determination, did not make a decision on whether we were right to bring that application in court at that time, but simply deferred this matter to this court and join us. And unfortunately, as I said, I will be the first one to concede that the horse is bolted before the stem, because the matter is already now in court. We are in a second day now of the hearing, and the question hasn't taken place.
Okay.
And that will be our submission, man.
So now, the relief you sought now just for the breach, because December has come and gone without any incident, and you also admit that there's just a rumor. So what this court should interdict?
My Lord, we were saying, unfortunately, my Lord, we were directed to come and appear before this court and be joined this proceedings. And the court on the 2nd made a determination either to grant our application or dismiss our application. We wouldn't be here. So we came here on the leave of the court that we need to come and be joined. But clearly our relief that we sought at that time has now been overtaken by the event.
No, Mr. Ndovi, you come here because the matters were consolidated because affecting the same people.
That's
so
correct.
It would be easier to deal with the matter at once rather than dealing with it in piecemeal, which could result in the conflicting judgments and causing a lot of problems. So that's why that matter was brought together with others. We were not forced to come here. You could withdraw the application because there's no need for it anymore.
My Lord, we of the view, because my Lord, if your Lordship can unfortunately there's no records attached, because we went through the whole process, my Lord, we went through the whole full argument, which now I'm just raising. We went through the full argument. So the court did not simply say, I'm not going to entertain your matter, I'm going to refer. So we went through the whole full argument. So we felt that maybe we are going to again, we'll be given this opportunity, or the court.
So at that time it was still before the 3rd of December or after?
It was on the 2nd of December.
Yeah, it was still before.
Yes, but
now
now
if you came on the 10th of December, will the court consolidate this matter?
No, my Lord, now remember, my Lord, the reason why the court accepted what it was placed on record by the President and the Premier, that there's no corruption that is taking place. So that we're seeking to interdict has now been put to rest. So our fear was already elevated to say there is no need for you to be worried. There is no corruption that is taking place. There's an undertaking from the office of the Premier and the President. And we're content with that.
All right, thank you, Mr. Ndovu.
Call please, my Lord.
Mr. Madonsela, and you have
Well, just few points on this aspect. This application has been overtaken by events. The court should not consider it. It has become academic. The court must only consider it only in order to determine the questions of cost occasioned by the application. And the court, in relation to the cost of the application, should dismiss the application on 3 independent grounds. The first one is that when Mbonisi brought this application, he had no business coming to court. In circumstances where he had not participated in the proceedings which he wanted to, whose outcome he wanted to protect. You'll recall, my Lord, that Prince Mbonisi was a party to the main applications, the Queen's as well as the Princess's application. He came to this court on a very truncated timelines, urgently, without citing other parties in the other case, asking the court to protect the outcome of proceedings in the Queen's and the Princess's application, in circumstances where he did not participate himself in those proceedings. In fact, he had elected to abide. So what business did he have to come to court to protect the outcome of proceedings he took no interest in? So those are the circumstances in which the application was brought. It was brought by a person who had no interest in the matter, who had taken no interest in the matter, but was suddenly bringing everyone to court, dragging everyone to court, in particular the opposing respondents to deal with a case based, which leads to my second argument, based on a pure rumor, grapevine. That was the basis of his application. He and others attended the funeral of the late Mgiliji Ntlego, the leader and the commander of the Zulu regiment. And on the basis of what was being discussed in the corridors, he then came to court rushing on an urgent basis, saying to court, there is an imminent coronation. Of course, there was none, because the coronation has got a very long process that must be undertaken before it is held. It is in fact the last thing to be done after the president would have issued a recognition certificate and investigated any dispute, if there were any dispute. We were just right at the beginning of the process. There was no basis for Prince Monisi to believe the rumor, if he had the rumor in a funeral, that there was an impending, let alone imminent, coronation of the king, in the absence of a government gazette issued by the president recognizing King Msusulu as the king. So, my lord, it was really short of lunacy for Prince Monisi to come to court on the basis of rumor mongering, which took place at the funeral. It is another to have come to court not having made any inquiries about the person who is in charge of coronating kings, the president or the premier. And it was completely unhelpful to come to us and ask us to confirm or deny the rumors of the rumor. We are the recipients of the coronation. No, when I say me, I mean the King Msusulu will be the one who will be coronated. He is invited, he's an invitee in that process. So for him to have confirmed, to come to demand a confirmation, to write letters urgently asking people within 24 hours to confirm or deny a rumor. Quite frankly, the prince and the king are very busy people. They can't be confirming every rumor every day. It was really short of lunacy for the Prince Monisi to come to court on that basis. Finally, my lord, there is no division. My little friend says there is division in the royal family. There is no division in the royal family. There are people who are mischievous in the royal family. Individuals. And Prince Buthelezi has spoken about it. And in the papers, this is in the papers, my lord. This is what he says about this very applicant, Prince Monisi, in the papers. It is cited and quoted in paragraph, page 75, paragraph 122 of our head document. Prince Monisi likewise did not grow up in the royal courts. His mother was not married to King Cyprian. Knowing this, we all applauded the way His Majesty King Zwelithini embraced him and used him to run errands. So Prince Monisi has no business. He can't run and drive the programs of the royal family. He can't cause divisions. He is not the royal family. Those who are the royal family have been articulated at length by Prince Buthelezi in his affidavit. And I do not want to waste the court's time as to how that is determined. It's found in the papers. I've cited it at length in the heads of the argument. There is no dispute about that. No one has ever disputed the dispute. Not Prince Monisi, not the applicants in the other question, have disputed who the royal family members are. So, my lord, for Prince Monisi to have come to court on the basis that he did, he should not have, and he was really misguided. We ask the court to dismiss the application on that basis. The reason why Prince Monisi remained in the case was to proceed with infelicity, proceed as he has done, to deliver heads of argument and raise causes of action and arguments which are not raised in his founding papers at all, and raise new arguments which are not even raised by the princesses and the queen in their own application. Two arguments have been raised. One is that in the heads of argument filed last week Thursday, we had to deal with completely new arguments which were raised by Prince Monisi not foreshadowed anywhere in the papers. The first one related to that there was the royal family had failed to develop a criteria to determine who the king is. My lord, you will seek and you will not find any of the amendments dealing with that kind of complaint in the founding papers, not in Prince Monice's papers, not even in the princess's application, not even in the queen's application. It was an argument sprang up last minute, which was
this argument?
in the heads of argument.
What is the argument?
The argument in Prince Monice's heads of argument, you'll find, my lord, at paragraph.
No, if you can remember, they'll summarize it.
No, he says the process is flawed because the royal family has failed to develop a criteria for the identification of the king. And then he cites a provision of section 2(1) of the Khoisan Act, a provision which incidentally does not even exist in the statute book, because section 2(1) deals with something completely different. That was the infelicity with which Prince Monice remained in the case and delivers heads of argument and pursues arguments not even raised in his papers, not even in other people's papers. The other argument that he raises, he pursued, was a flaw with regards to the minutes in the meeting. In other words, Prince Monice decided of his own, in the context of an application which was already academic, to piggyback on the princess's application and run a case which he did not participate in and which he did not assert or traverse in his own founding affidavit. So, my lord, this was really an aberration. It was an application which was, if anything, of nuisance value, because it had been brought by a person who had no interest in the matter, bringing up a case that had not been argued by anyone in the principal application. The issue and the criteria with regard to traditional leadership, if anyone wants to know, is set out in the constitutional case, not the case of Mpepu that Madam Fred was talking about. And Mpepu, frankly, has nothing to do with this case, because insofar as the Bill of Rights are concerned, the issue of traditional leadership, which has been said by the Constitutional Court in Mkhize versus the Premier of the Province of KwaZulu-Natal, we cited authority in the very first opening paragraph of our heads of argument, where the Constitutional Court judges issue a refrain on issues of traditional leadership. And it says, and I quote, "The law governing traditional leadership is customary law." Why do courts attempt to resolve traditional leadership disputes by employing the common law? So this idea of people coming to meetings to nominate a king as if it is an election process is foreign to our traditional leadership. Like with the Jews, our system, our idea of heritage, of heirship of the throne or succession is hereditary. A king is not elected in the African tradition. A king is born. In the words of that great prophet Isaiah of the old, "Unto us a king is born." We ask that this application be dismissed.
Do you have anything in reply, Mr. Ndongo?
Court presses, my lord. Lord, Madam Friend has argued that we quoted section 2(1) of the Khoisan Act and the same does not exist. Lord, may I refer the court to section 2(1), and I read that for the record now. It's the guiding principle. Section 2(1) reads as follows, my lord: a king or queen or queenship, a kingship or queenship principal traditional community, headmanship, womanship, head womanship, Khoisan community must transform and adopt customary law, custom relevant application of this act so as to comply with the relevant principle contained in the Bill of Rights in the Constitution, in particular the preventing unfair discrimination, promoting equality, and seeking to progressively advance gender representations in the succession to the traditional and Khoisan leadership positions. So, my lord, the section is there. And I invite my friend, my own friend, to go and revisit that act. It is there, so it's not misplaced. And my own friend, I will advise him, my lord, to turn the page, because he will find it.
He has been telling other people to turn the page, he has been failing to do it himself.
My lord, and I've made a point, my lord, that we had all the rights to come here to this court, and our legitimacy to the royal family, my lord, I will still submit, my lord, that it cannot be questioned. And the fact that, my lord, Prince Buthelezi wants everybody to accept and believe that he's an alpha and omega of the Zulu Royal Family, the Zulu Royal Family. He abrogated this position of being a prime minister to be the senior person above any royal family members. He says in his affidavit that he's the only person who can call the royal family meetings. He's the only person who can preside over the ceremonies of the royal family, and what we and now relegate any other person who dare challenge him. And what I submit that is being petty when he says simply because the Prince Mbonisi's mother was not married to the king, therefore he cannot lay a claim to the throne. What I submit that is misguided and is misplaced. My lord, we say we were invited by the court to make submissions, and we made submission based on what the court has invited us to say. And we say, my lord, that the reference to the meeting that is flawed is not misplaced. It's based on the invitation by this court. And we set out the reason why we said that the meeting was flawed. And it's for this court to determine, not in isolation, in light of what the princesses have said in their papers, that the process is flawed, and therefore if the court is with us, then the court will make a determination, will then rule that the person was flawed, and the matter will then be referred back to the royal family for further consideration.
Which matter will be referred?
My lord?
Which matter will be referred back?
No, the issue of nomination. If the court is with us, will then interdict that process, and it will therefore follow that the person will have to start de novo.
Well, that would maybe a position if there has been some person who is a meaningful contender. But in the absence of the contender, who are the contenders, then the royal family have to choose between or amongst. There's a problem. Because if you come up with somebody and say this is the person, we put up this man because of this and that, and then there's also the person put up by the customary law and tradition, and then there should be a comparison between the two. But now what people forget is that this is decided in terms of the customary law and traditions. That's what the Act says, that's what the cases says, that is the position also, because each and every nation has its own customs and traditions. They are not similar. Some are similar, some are not. Some are likable, some are unlikable. Some are palatable, some are not. So it depends on that. But I hear you, your submission.
As a court president, I will have no submission.
Thank you. Is the interpreter still around, or she has disappeared into the thin air? So, do the people want the interpreter to summarize this because we are finalizing it now?
Apologies.
Interpreter, we're looking for you, but we are not found anywhere.
My Lord, I apologize. I was dying.
Okay. So just give us a summary. People are in a hurry, but those who want to know, they will be eager to know what's going on because they have an interest in the matter. Yes.
Silalele ke manje kubekile impikiswana ke la kodwa ke kumayelana nodaba lwesibili lamazinyane silo la lifaka isicelo sokuthi ke cela inkantolo inyaze udaba lokuthi ke kumiswe la ukuthi ke kugcotshwe noma ke mayelana nodaba lokuqoka kwesilo ngenxa noma izathu bebezile noma ukuthi bayaphikisana nodaba ke leyamafa kabayeke yokuqoka ke lapha kuvukazi lengasekho ngoba siyakhuthama izathu bayibhezile ngenxa yokuthi ke lapha kuyaphepha nokunye kuningi ke ababekele izathu lapha kothawini kunezinto ezisolisayo ukuthi kukhonisa lesempela ekutheni kuney'nguquko ezenziwa lapha ke nokungafani kwezandla lokho abakubekile cha kahle kahle le nkantolo nakubona ukuthi izonquma ngodaba laleyancwadi yekabayeke nayeqoka khona ke intokazi siyakhuthama kodwa kumayelana ukuthi ke lesikhathi kusale ukuthi ke ngoba lelo daba livele sesezithenzile enkantolo kuyona ezonquma ke lapho ke mayelana nalokuthi ngabe le ncwadi yefa le iyiyo noma ke cha ayigodwe kuphela ngoba leyo ncwadi noma ngokuchaza ukuthi njengoba kwaqoka lowo intokazi kube nawo phela umthini lokuthi njengamanje bese ke kuqokwe lowo noma kuphansi igama layo inkosi ke uMisizulu noma bengazange bakuveze ngokusobala noma ke la ukuthi ke bana ukuphikisana nokuqokwa kwenkosi noma lo osechaze lomuntu uyena ozongena ezinyaweni zabayeke la kodwa baveze nje ukuthi njengamalunga omndeni nabo phela banalo ke ilungelo lokuthi abavezile baveze izinto eziningi ezingahambanga ngendlela ngesikhathi kwenza yonke le nqubo ngoba uma ngabe sifuna ukuthi kuzoqokwa ke umuntu oqala lehlobo njengoba ukukhuthema ubayeke kunenqubo mgomo eyaye ilandelwe kodwa bona abaveze nje ukuthi kulo nqubo mgomo okufanele ke ilandelwe noma ke yenziwe kunezinto abangazange batshelwe zona njengokuthi nje kweminye imihlangano kulo mhlangano lapho ubona njengamazinyane silo ayikade bizelwe nje ukuthi kuzohlanjululwa emveni kokade ke kukhothame indlovukazi kanti sekuyilelanga leli ke sekuqokwa ngalo noma sekuphakanyiswa igama lika uMisizulu njengozoba ke inkosi manje lokho ke kukodwa bekubona kubabona noma kubachaze phela njengabantwana basebukhosini sebezibone besebeshiye ngaphandle ekutheni ke phela nabanalo ilungelo kodwa ke kule phakamiso zabo ubese kupetula into eziningi noma lesikhathi ke begadla bona siphukile noma ngachaza induku bawo ziyashaya kodwa zihambe ziyaphuka embuzweni ebeyivela phela ukuthi siyezwa isiphakamiso senu sokuthi bazinyana silo niyaphikisana bethi akugodwe ukuthi ke kuqhutsheke lenqubo le yokuthi ke na kugcotshwe kube nembuzo inkantolo beyibuza ukuthi chazani ukuthi ngabe bese kusho ukuthi uzogcotshwa na ngoba phela kunemdanto noma nemila izinto eziyezandla ikepisi eziyenziwe ngaphambi kokuthi uze kufinyelele lesi step lesokuthi bakuthiwa seyogcotshwa inkosi ke la esizweni ukuthi njengesilo noma ubayede wethu kunezinto eziyezilandelele sezenziwe zonke lezo zinto bathi cha bona bebevimba leyo nqubo esazolandela ukuthi nje ayisheke imiswe nanokuthi phela manje okunye kubashayela ukuthi uma bebuzwa la noma engathi ezinye zezinto ebesiphinde sibuzwe kubona ukuthi kungabe njengoba ke niphikisana nithi ubani okuyena ofanelekile noma uma ngabe nisakhamiswe lokho mhlawumbe ninezathu ukuthi nisakhamiswe lokho ngoba ninomuntu enibona okuyena zingeni noma ongama kangcono ke kulesi sikhundla nakodwa kube ukuthi uma beveza hayi ngoba bephikisana nokuthi igama leli liphakanyisiwe lenkosi ke uMsizulu nanokuthi uye phinde-ke kwavezwa noma-ke kwayinkulumo eshaya kakhulu-ke mayelana nodaba lokuthi uma sibheka ngokomthetho nje wesintu-ke la indlela okwenzeka ngakhona ukuthi bayakhumbula yini ukuthi ngokomthetho phela lo wesintu uma ngabe sikhuluma ngokuthi inkosi-ke inamakhosikazi la ubani obasethubeni la kulabo ndlunkulu bebonke obasethubeni ukuthi yena-ke mhlawumbe achazwe njengendlovukazi lapha bese kuchaza ukuthi kunosuke elotsholwe isizwe lo suke elotsholwe isizwe ulotsholwe isizwe ngenhloso yokuthi phela uyena ekubheke ukuthi uzothi uma ethola umntwana loyo umntwana womfana uyena mholi noma muntu osethubeni uyena muntu kahle kahle ayinokuthi usethi uyena muntu osuke ekubheka ukuthi ozothatha iy'ntambo zababa wakhe uma kuba lesi esifana nalesi ekhothama nanokuthi futhi ukuphinde kungezelele kakhulu-ke kulolu daba uma sikhuluma ukuthi-ke lo undlovukazi ozala enkosini noma lo sekhethwe njengenkosi uMsizulu ozalwa-ke ebukhosini laseSwatini okusho phela manje njengoba abanye ondlunkulu bona bengazalwa ebukhosini lo ukuthi uzalwa ebukhosini sekunika amathuba angcono noma uyila phela yena lo esekunkulu ukuthi abe undlunkulu kodwa abe yindlovukazi ngaleyo ndlela thina laba abanye bawondlunkulu kodwa yena useba yindlovukazi ngenxa yesimo sokuthi-ke uzalwa ebukhosini ulotsholwe isizwe ukuthi lowo mthetho bayawubheka yini ukulandelela cha bavezile izathu-ke nabo abayichazile zokuthi isizathu salokhu yingenxa-ke yokuthi phela manje bona bayabona ukuthi kusho kwakhona okungahambanga ngoba ingqikithi akuyona emayelana ngokwamazinganisile ukuthi mayelana nencwadi yefa leka yendlovukazi yokuqokwa noma ukuphakanyiswa kwegama likaMsizulu kodwa indaba isemuva ile encwadini yefa likabayede ekuqokweni kwakhe nje la manje babona kube nawo umthelela kodwa kube nembuzo emiyikhambile ukuthi ngaba kunjalo yini ukuthi ngale kwencwadi yefa kunezinye zezinto ezilandelele njengokuthi umndeni kahle kahle wasebukhosini abantu baqala noma bona bakwandlunkulu balapha esikoleni ibona phela bebe umhlangano ukuphakamisa igama lokuthi-kena usibanibani yena na ufanelekile ukuthi-ke avele nanokuthi uphinde kwavele ukuthi impela kwaba khona imihlangano ebekhona ngalesa sikhathi-ke kusaphila indlovukazi leyakhothama la kwazi kwaphinde kwavezwa khona umntwana kumbonisa kwaphanyiswa igama kodwa lapho kwaba khona iy'ngxoxo ngempela ngoba amaphepha kukhona okubhalwe phansi ukuthi akuzange nje bekuthi kwaqokwa sekuqokwa le ndlovukazi yakhothama kwaba khona ingxoxo kwabuzwana imibuzo kwaphendulwana kwaze kwawukuthi-ke bavumelana ngoba kuze kuvele noyedwa wezinyane lesilo owayekhona laphana lo mntwana-ke sithathe njengoMntombi weSuthu owaphawula ukuthi cha ngempela kungani singahloniphi ngokwemiyalelo kababa nje ubaba wayekade yena encwadini yakhe leyefa ebhale indlovukazi yakhothama ngonokuhlonishela kokumukelo lokho kwasekhoxiswa ngelela gama lakade phakathi kodwa sizwile-ke obamele kuphakamile-ke inkosana kaQulu ngiyaphindadelela ngapho ukuthi cha inkosi yankantolo kufanelekile yini ukuthi umuntu uma ngabe kade esho into ngaphambili uma ngabe-ke into esephinde wayibona ngelinye ihlo noma eseyibunga phela ukukhuluma nento ebhalwe phansi-ke akufani ukuthi-ke lokho phela nje abantu base bephikisana lokubhalwe phansi ukuthi-ke lokho ngabe babunga amalungelo abo ukuthi kubalele ilungelo labo uma bebona ukuthi khona-ke isandla sempela noma okungahambi kahle na lokho kodwa-ke bese kuveza ukuthi cha ngoba bemukwa ilungelo labo kodwa phela bona abaveza izathu zokuthi njengoba bephikisana naleya ncwadi ngoba phela leya ncwadi kahle kahle ngokuy'phakamiso zabamele abaphikisana nesicelo sabo bakubeke ngokusobala ukuthi bona bayabona nje ukuthi ubona ukuthi uma uzoliwe ngokolimi lwabo ngoba singabaZulu bayichaza ngokuthi kulwelwa nje yabona manzoba ngithambo engenanyama ngoba bona babona ukuthi kahle kahle uma ngabe bona bengaphikisani nezwi noma nencwadi le kaNdlunkulu noma incwadi kaNdlovukazi lokuyena owaqoka ngoba inkosi noma ubayede akamqokanga lo mntwana umntwana omisiZulu kodwa kuqokwe indlovukazi yakhe naye yakhothama emveni nje ukuba sekukhanyiswe igama layo yasiyabhalwa ukuthi-ke ukuhlonipha isifiso somyeni wayo nanokuhlonipha umthetho namasiko-ke akaZulu ubona umuntu okuyena ofanelekile ukuthi makathathe la umisiZulu wakubhala-ke konke lokho nakuyiwili-ke wabe seyakubhala kanti akuphelelanga-ke lapho kuphela sizwile futhi kunolunye uhlangothi kwabameli la omele umntwana umbonisi naye insizwa ntombi iyabhadla ngiyakhahleka ngempela ukuthi cha ngempela le nto abeyibheke nhlangothini zonke kungabhekwa uhlangothi olulodwa ngoba phela manje bona kahle kahle ngokwesicelo sabo kuze waqhubeka ngokusobala ukuthi noma besime thina noma sizophamisa isithulo sethu sincike omana ngitshele noma kuyinzwa bethi kodwa kanti besilungisa ukuthi hhayi ngabe kume kanjani ngathi cha nami ngiyakulungisa phela le nto ibalulekile futhi kuyinto ezoba nomthelela omubi kuthina uma ngabe sekukhulunywa ukuthi usuku oluthize kuzogcotshwa inkantolo ekubeni futhi singabanga nazo iy'mpendulo eziqotho la besibuza khona ukuthi abasichazele basitshele ukuthi kahle kahle njengoba kunalabo mana ngitshele noma labo abasichazela ukuthi kuzogcotshwa inkosi kwenzakala nini sangakuthola bonke lokho sesakuthola ngomzuzu wokugcina kuwukuthi vele sesasavela inkantolo yangaphambili esavela kuyona iyaseluleka ukuthi asingenelele noma sifakwe-ke la njengoba phela sibona sinemdiki munye-ke la silwa izinto ezahlukene kodwa sisonke-ke la sathi siyangenelela yebo kona usuku selidlulile ngoba inkantolo ibeyigcine nje kutheni kodwa-ke mfoka ngiyakuzwa uyakhuluma ngalo daba lokugcotshwa ungabe ukugcotshwa kwenkosi kunini mhlawumbe usuzwile ukuthi usichazele kodwa ube sekubuya kusoka cha kodwa inkosi yenkantolo into ebuyayo ngokuphelile kwakhulunywa ngoDisemba kwawukuthi kodwa phela ngoba nami sengize ngaboshwa noma sengize ngafakwa kodwa-ke insizwa ayiphelelanga lapho ibe sibhoboka kathi cha kahle kahle ithumba linda ukuthi sinako ukuphikisana nokuthi kugcotshwe noma lokhu ukuqagulwa kwenkosi umisiZulu sinako impela ngoba kunezinto ezingalandelelwanga ngendlela umthetho awulandelwanga ngoba thina silwa nalokho ukuthi uyabona uma ngabe sikhona sekhosini esikhala ngabo ukuthi yindaba bangathi ukucindezela ilungelo lomuntu uma ngabe mina ngiwumntwana ozalwe ngale kwasemshadweni ngingazalelanga emshadweni bese ngingabi sethubeni lokuthi nami phela ngimele ukuthi ngilole isikhundla leso sikababa bese ngikhishwa inyumbazana umuphi umthetho osho njalo ngoba phela umthetho ukuthi asiphathwe ngendlela efanayo nelinganayo ukuvezile nje lokho zange ananazo cha umthetho uyaveza waze wacaphuna-ke lapha nalapha-ke emthethweni obekumsekela ukuthi lokho phela kufanele inkantolo iphinde ibhekelele phela kwabona lokho ukuthi-ke lo amele umntwana umboniso akube ngathi ukhishwa inyumbazana uma ngabe yena ephakamisa-ke uvo lakhe noma-ke eveza-ke lokho phela naye umboniso ubekhala ukuthi cha ngenxa yokuthi kunezinto ezingahambanga kahle lesikhathi kuqokwa noma-ke kukhonjwa kuphakanyiswa igama leli kungcono kanti ukuthi godla ukuthi inqubo le yokuthi-ke kuze kufuneke kutheni kugcotshwe kube ukuthi yonke into iyalungiswa-ke kodwa-ke uphendile-ke awumele noma ngizomchaza ukuthi-ke umnumzane Madonsela ukuthi cha kahle hhayi ngoba mhlawumbe kukhona ukuthi-ke lapha-ke usekunoqhekeko lapha esigodlweni kodwa nje phela yonke indawo kuba khona ongumina yona labo nalabo asebemosha-ke izinto nangendlela ngoba phela uzokuveza ngokusobala incizelo yomntwana aphinde angene ngoba phela ukusubheka ukwenza noma aphinde adalula ngokwenza kambonisa ukuthi ekuqaleni wayekade emdibini kodwa eseyiqhinanisa nayo yonke le uyicicike manje sezozimela lapho esefaka khona isicelo sakhe-ke esezimele-ke yedwa eseceleni uthi nje uyacela yena ngokwakhe impela ukuthi lezi celo nje fakiwe nabasekelana ngazo nhlangothini zombili ukuthi uyacela emkhathini ukuthi phela mayizichithi ingasimukeli kanti-ke nommeli-ke umsizi yena uyo wafakazelana nobe kule section nomnumzane uMadonsela.
Thank you. Mr. Redman, still around is gone.
nullify was
Oh,
asked by
okay,
my leader
Mr.
to
Kulu,
apologize
I
then.
want to know this matter. When will I know when the matter will be referred for trial or the hearing of oral evidence on the signatures?
The situation is at this point that in a period, according to the notice of motion, we had sought that the matter be referred or that the summonses would be issued within, if I can correct my note, within a period of 15 days after the institute was granted.
Okay. So then who will set the terms of it?
But given that the matter has been ventilated in full before this court, we would ask that this court, or in the alternative, as previously directed by this court when the matter first was dealt with in chambers, that a timeline for such be either be determined by this court or in the alternative, the representatives of the applicant and the respondents affected set this necessary timeline for that.
I'll appreciate also to get input from you people as well. Well, we'll take time on this matter. What a chance.
Oh,